বেশি চলছে বন্ধ করে দিতে বলবো না।
My lord, we are permitted to mention one matter under item number 64. This is a senior citizen matter, my lord. Last week I have mentioned, my lord directed me to mention this
It will
week.
be reached, sir.
My lord,
It will be reached.
listed. Since September it is appearing in the list.
Last week for 4 days we called this up the combined.
No, my lord, my junior was there, but no state advocate was there.
That is why it was called on.
It is called on.
So let it be there. Don't break the serial. We will reach the matter. If it is not reached for 2 weeks, then you remind us.
May I, Your Lordships, kindly leave to mention a matter, my lords, upon notice for inclusion, Your Lordships. The pleadings have been completed. Your Lordships, the matter is ready for
Hearing
argument.
matter.
It's a hearing matter, Your Lordship.
What
It's very
land?
Section 14 proceedings by the competent authority, Your Lordship. The writ is against Section 14 proceedings, Section 14T, vesting matter, Your Lordship, of the land reforms, Your Lordship.
14D.
14T, Your Lordship.
14T. Which year appeal?
Your Lordship, the latest can had been filed in 2022. It had been heard fully. Interim order had been passed in that. The writ is pending since 2012, Your Lordship. Despite that, the state is proceeding.
Give the slip combined list. Yes. Yes, Mr.
My lord, I'm praying for inclusion of our group
Grateful,
sleep
Your
application, my lord.
Which year, Mr. Mohabbat?
2024, my lord.
Huh?
2024, this year. Application.
You are mentioning about notice.
My lord, upon notice.
Near of
My lord, I am mentioning upon notice, my lord, this is a hearing matter of 2024. It's a pensioners matter for the release of six pay commission, benefits of six pay commission. There are 73 writ petitioners. They are appellants, state is appellant, and the appellants are enjoying interim stay, my lord. I am praying for the.
you take necessary steps, madam.
I am not stay, my lord. I am the writ petitioner.
So against you, an interim order is there.
Yes, my lord.
So you take appropriate steps against that.
I have
No,
to.
no,
I
what
have
is
to.
this is all of them are retired. They have already got their pensionary benefits. Now you are seeking refixation on the basis of the sixth pay commission.
Yes, my lord.
Not so urgent, madam. It is not so. If an interim order is there, you know what steps are required to be taken. Are you
But
mentioning
my lord,
about
matter was returnable in the list of monthly list of October, my lord.
we pass the order?
No, my lord. The coordinate bench.
Niye rakho dekho.
Lordship, may I permit to mention restoration
Yes,
application?
Uh-huh.
Restoration application.
For notice you are mentioning?
Yes, madam.
Yes. Take.
Now I am appearing for
Yes,
the
Mr. Ghosh.
I am appearing for the respondent number 4. The on 19 November, the learned tribunal will already dispose of this original application.
Disposed of.
Challenging one notice, the tribunal application has been filed before the learned tribunal.
So it has become infructuous.
So since the original proceeding is not there, now they also.
Where is the order? Which order they impugn, Mr. Ghosh?
Kindly come to the page 9 prayer A of the writ petition.
No, the order against.
No order passed. At the instance of I file an respondent number 4 file application for correction of recorded rights before the concerned authority.
You are the original applicants.
Yes. No, I am the one of the respondent.
So they filed an application for
Challenging that for correction of recorded rights, I approach before the revenue authority. Revenue authority in response of my application issued notice. In that notice, I was the applicant and they were the opposite parties.
That notice is impugned in this writ petition.
Yeah, impugned in the original application as well as in the writ petition also. Kindly see the prayer A of the writ petition. The page 19 is that notice.
So how can they come to court directly before us? Page 19.
Page 19, that notice was challenged in the original application
By the
by the writ petitioner before my lords.
oh, I see.
And self-serve notice has been
Challenge
included in this writ petition.
In this writ petition also. Now, on 19th,
What happened in
your
the
other
meantime?
19th November was fixed for hearing of this application. They did not appear before the learned tribunal. Learned tribunal was pleased to dispose of this original application by
You possess the
directing.
certified copy of the order.
That yet not yet been served.
Have you? That has not been served. 19th October.
19th November. This last
19th
month.
November. Who is your other side? You know him.
They did not appear also before the learned tribunal also.
We mentioned it.
You mentioned by another hearing this
The last occasion in the this matter appeared in the monthly list of November. On that day also they did not appear.
Substitution was allowed.
No,
In this matter,
that is prior to that. In the November monthly list matter appeared. On that day, since they are not appear, my lord was pleased to fix the matter, the December monthly list.
What is can 2 for?
Can 2 আমাদের
হচ্ছে for
Can 2 টা can 1 একটা order 1 rule 10 আছে addition of
আমরা এক্সামিনেশন চেয়েছিলাম কেন
আমি জানি না আদার সাইড another heading for dismissal রেখে দিন না একটা withdraw এগুলো আছে
লিস্টে আছে নাকি?
can 2 filed by my client the respondent number 4 for injunction. So in view of
So no one appears on behalf of the petitioners, though Mr. Ghosh learned advocate appearing for the respondent number 4 is present. Stop. He submits.
My lord,
If you know your other side advocate, please tell him that it has been kept.
My lord, Mr. Bikash Ranjan Bhattacharya is appearing on behalf of the appellants. My lord, I am praying for a short passover, my lord.
My lord, in this matter, your lordship kindly fix a not today, my lord. Only not today, my lord. I am appearing on behalf of the Coal India, my lord.
No, not today. We'll take it to the next combined list.
No, my lord,
My lord,
kindly.
only my lord, 1 day accommodation, lordship, because lordship, only 1 day, my lord.
Not today করে ওইটা যখন combined list এর ইন্ডিকেশনটা দেবে item number এত and
I'm grateful.
Yes,
Not
not
today, not
today.
today.
Next.
Grateful, lordship.
Grateful.
My lord, I'm for the writ petitioner, my lord, respondents.
Who is your others?
My lord, I am for the appellant, my lord, led Mr. Shishona Bandopadhyay, my lord. My lord, there was a direction upon the committee to file its report, my lord. No.
Done.
My lord, the report is ready, my lord. I've just received a copy of the report on WhatsApp, my lord. May I come back tomorrow, my lord? I've just received the report now, my lord.
No, that has to be given to them, no?
My lord,
My
we'll
lord.
give it to them tomorrow, my lord.
Conclude the proceeding.
The proceeding has been concluded, my lord.
My lord, the issue is one of the petitioners is going to retire on the month of December, my lord. So expeditiously may they give the report, my lord.
জানি না এটা অন্য ঘর থেকে এসছে তো it will be
আমি বলছি কালকে
next Wednesday রাখ it will be in the supplementary list next Wednesday
কন্টিনিউয়াস বলে যাচ্ছি কোনো হয়
you bring the report
My lord, report was ready, my lord. I don't know why my client did not send it, my lord. Report was ready. I read it.
then you do one thing that report you give a copy to your other side
And
was there any earlier direction
not to serve, but only to produce, my lord.
which was the topic
My lord, I'm led by Mr. Sommo Mujumdar.
কপিগুলো আছে এটা তো কমিটি ফর্ম ছিল বুঝছিস
That will be 19 July, my lord.
আমাকে পাঠিয়ে দিয়েছে তো ঠিক আছে
Mr. Bandyopadhyay, learned advocate appearing for the appellants, submits that pursuant to the earlier order passed by this court, hearing had already been conducted. That is the
What?
writ petition.
My lord,
There were other writ petitioners
my
also.
lord,
There were
four writ petitioners, my lord, overall.
who is appearing for others.
My lord, I am appearing for
For all
others,
of them.
all of them.
For the writ petitioners stroke respondents.
Respondents.
Grateful, ma'am.
Grateful, ma'am.
Now, requested to hand over a copy of the said report weight to the learned advocate to the learned advocate appearing on behalf of the writ petitioners stroke respondents here.
Okay.
Huh? Oden.
Yes.
You take a copy.
My lord.
Again for them to again mail it again.
I'll give it.
Yes, next.
My lord, I am appearing on behalf of the respondent writ petitioners, my lord.
My lord, Tonoy Chakraborty is appearing in this matter, and due to his personal difficulties, he is unable to conduct this case. So
ওই next
kindly-
Thursday করে দাও next Thursday it will appear. Any urgency is there?
No, my lord, there is no urgency.
First time it has come.
Before your lordship first time come, previously before the coordinate bench was declined to pass any interim order. Time to time heard the matter, and thereafter, before this matter has come before your lordship on the after vacation, my lord, and thereafter they did not appear. Your lordship was pleased to place the matter on. And we have filed the contempt application where, my lord, the learned single judge was pleased to issue contempt rule twice, and thereafter not last occasion, my lord, the learned single judge held that the principal secretary of the government of West Bengal should be sent to jail for 2 months. because for filing the sham compliance against the order, they went before the Supreme Court, and the Supreme Court was pleased to pass its limited stay order, and that stay order is still, my lord, 11th January 2025.
Then when Supreme Court is insisting, Mr. How can we,
Well,
Mr.
so far the-
Pal, how can we hear?
Against the contempt order, not against the main order, my lord. The contemptor went before
the contempt, when is the
contemptor, Mr.
contempt returnable?
They are returnable on 7th January.
Before the Supreme Court.
Before the Supreme Court, and up to 11th January, my lord, there's stay order. So far, the contempt rule against the contempt rule, my lord.
What is the matter about?
My lord, here the learned single judge was pleased to direct them to regularize the service of the 2 bus drivers against the permanent post. Because time to time they have regularized the service of some conductors and some drivers, my lord, who are much junior to the.
No one and today an adjournment has been prayed for on behalf of the appellants, though Mr. Pal, learned advocate, appearing for the writ petitioner stroke respondent numbers 1 and 2 herein.
My lord, I am appearing for the
company.
My lord, may I be permitted? My lord, I am appearing for the respondent number 4 and 5, my lord.
And,
the respondent corporation.
And Mr. Pal, learned advocate, and Mr.
Chattaraj.
Miss Deblina Chattaraj.
Appearing for the numbers 4, 5, and 7 are present. In view thereof, list the matter for further consideration under the same heading in the daily supplementary list of this court on 16th December. Yes.
16th.
Grateful, my lord.
Lordship, I am for the appellant, Lordship. Lordship, the affidavit service, the service was returned back to me with a remark unclaimed. There are 2 can 1 is for condemnation of delay, and can 2, by mistake, state of West Bengal has made a party for striking a deletion of state of West Bengal.
What is can 1?
Can 1 is for condemnation of delay. Delay is of 3 days delay, Lordship. Can 1.
You have served. You have served the
everything, Lordship.
You have served upon the learned advocate.
Learned advocate.
Why not the upon the respondent directly?
No, learned advocate for the advocate was in the writ petition. In the single bench, he was the advocate.
But
you have direction to that effect.
Service has been created, but service has returned to me. Everything has been there. Can 1, can 2.
So your service was upon the advocate.
Advocate.
So advocate not claimed how it will be good service. You have to serve upon the person concerned, the writ petitioner.
Respondent who is the
Kollan Kormokar.
Kollan Kormokar. No.
This you have served upon the advocate.
Advocate. Advocate concerned.
No. You have to serve upon the respondent directly, no?
Can 1 is an application for stay, and can 3 is an application for striking out the name. And can, where is your delay? Delay application is can 2.
Can 2, Lordship. Delay was of 3 days, Lordship.
The affidavit of service as filed today
6 minute, I am for the respondent. I am for the respondent number 1.
Who is for the appellant?
Miss Tanushree Dasgupta is appearing, my lord.
You got the applications? Can
Yes, I
one,
have
can
the
two?
copy, my lord. Now, if I have already filed a contempt, the returnable date is on 20th. So if next week my lord may fix any date, I may communicate to the appellant, my lord.
There is a 41 days delay. Appropriate condemnation of delay, appropriate order.
In our application, the portion of the delay, they have kept it blank.
No, it is the report of the stamp reporter.
Oh, stamp
It is a
reporter, yes.
41 days delay. So the direction was to keep one post vacant. So how they are agreed by that? Against that they have come up.
Yes, and in the meantime, I have, my lord, submitted the
Caste certificate.
yes, what they are asking me, the economic weaker section certificate for a particular year.
Then what happened?
No, they did not consider it. Through mail, my client sent it to them. I have also sent them notice and EWS certificate I have submitted and said that if you want, we can produce the original also. Now they are, my lord, they have only taken mainly 3 grounds. One,
No, wait, that is on merit. Let
yes,
us understand. ওই সেদিনকে the appellant is not represented today.
I am accompanied with Mr. Anushko Das, my lord.
Lordship, I'm for the appellant.
Oh.
Lordship, praying for apology, Your Lordship. I'm a bit late, Your Lordship. Lordship, the contempt application is fixed on 20th, Your Lordship. So, কি ঘন্টার হতে গেল এর কাছে?
17 তারিখে এটা ফিক্সড করেছেন।
শুনছি তো।
অলরেডি অর্ডার পাস। কমিউনিকেট করার অর্ডার।
In which paragraph of can 1 you have stated about the delay? Cause of delay?
Lordship.
Paragraph 9.
Paragraph 9, Your Lordship.
9 and 10.
Lordship, it is because of the decision-making process of the officials, Your Lordship, the entire appeal was preferred late, out of time, Your Lordship.
Are you opposing the case?
No. We are not opposing the Section 5 application. We are not opposing. Delay may be condoned.
Can 1 of 2024 is an application for condonation of delay in filing the instant appeal. You obtained the extension of the interim order. The interim order is not there. It was till 30th September.
Yes, 30th September, but the writ was disposed of. So immediately after, we filed without contempt application. Interim order was.
What is the wrong with this order, madam?
Lordship, the
Just a moment, let my brother.
How you are agreed?
Lordship. Lordship, at the first instance, your Lordship may be permitted to place the operative portion of the impugned order, that is page 118, because the opportunity that was given to the petitioner to submit the EWS certificate late, but the reason that has been given, your Lordship, it is page 118 of the impugned order, your Lordship. I may be permitted to place that just prior to the 119, it's the paragraph starts from 118, your Lordship. Last paragraph, if the certificate for the year 2022-2023
Read from the paragraph beginning, which
Lordship,
paragraph?
paragraph 118, last paragraph, the petitioner says,
Just. You have an
internal page 2.
Internal page 2.
Internal page 2.
This is the annexure F, your Lordship, annexed with the stay application.
Yes, the petitioner says.
The petitioner says that the employment notice dated 21st January 2023, and as such, the EWS certificate for the financial year 2023-2024 is the relevant one. The petitioner has already submitted the same. LICI, according to the petitioner, by calling for the EWS certificate for the year 2021-2022, is attempting to change the rule of game subsequent to the completion of the selection process. If the certificate for the year 2022-2023 based on the income for the financial year 2021-2022 was necessary, then LIC could have asked for the same beforehand to enable the petitioner to obtain the same and produce it. LICI has called upon the petitioner, Lordship, this is important. LICI has called upon the petitioner to produce the certificate within 4 days, which was an impossible task, as the petitioner has no control over the issuance process of such certificate. So, my lord, the learned single judge, honorable single judge, has been pleased to consider that only 4 days time was given to the petitioner to obtain that. But that is not the position.
Obtain the certificate for 22-23.
But that is not the position, your lordship, because at the time of the advertisement, as subsequently, your lordship, there were several undertakings which is on record, your lordship. If my lord comes to page 47 of the stay application, the undertaking has been given by the petitioner, annexure D, your lordship,
Relevant year is 2022-23.
23, because the cutoff date is 1st January 2023. Advertisement was published on 21st January 2023.
Just a minute. You demanded EWS certificate for the year 2022-23.
And despite giving the undertakings on several locations immediately at the time of giving the declarations.
Very good. No, there was.
My lord, there is another issue, your lordship. This an annexure D, and there are several undertakings which have been given.
He has undertaken to produce 22-23 certificate.
Yes. Despite that, what is the date? When annexure D, page 47. When did he give the undertaking? He gave the undertaking on at the time of medical examination, 16th of February 2024.
What was the date of the advertisement?
21st January 2023.
21st January 23 was the advertisement.
And the cutoff date was 1st January 2023.
Cutoff in the sense?
Cutoff in the sense regarding the eligibility and all the criteria should be till 1st January 2023.
1st January 2023.
Date of advertisement. Date of advertisement.
21st January 2023.
What is the last date of submission of application?
The cutoff date is 1st January. All the eligibilities will be considered still 1st January 2023.
Very good.
21st?
1st January 2023.
1st January 2023.
Now, after these undertakings given, your lordship, my lord will come to page 80.
This undertaking was given when?
This undertaking, there are several undertakings, your lordship. This is one of the undertakings which I am...
16th February 2024. Undertaking was given on 16th February 2024 at the time of medical examination.
Prior to that also, when the lordship, when the advertisement was given and when the petitioner replied, then also he given the undertaking. And the most interesting part, your lordship, in this, which is the impugned order is beyond the record, your lordship, my lord will consider page 80. Page 80 of the application, your lordship, wherein there is an acknowledgement slip. Acknowledgement slip indicating submission of an application before the concerned authority for obtaining the EWS certificate. When this acknowledgement slip was obtained, was given, it was on 29th of February 2024. So he gives the undertaking earlier and submits to applies to obtain the EWS certificate later. So all these undertakings is beyond the terms and conditions of the notice. He gives the undertaking, continues with the entire process. He gets eligible. Subsequently, your lordship, the 4 days time which my lord has been pleased to observe, that is after this, your lordship, there were several letters were given to the petitioner that requesting the petitioner to submit the EWS certificate. That was the last letter which was given on 22nd February.
So according to you, madam, 2022-2023 EWS was necessary.
That was necessary, and
his contention was when the advertisement was floated, it should be when it was said that recent EWS, latest. He gave. Now, after considering both, court has upheld your view that yes, 2022-2023 is required. Unless he can produce the same, it has to go. And court exercised discretion in his favor, extending the time to obtain that certificate.
The difficulty
now, before you entered the courtroom, he said that now he has already got the certificate.
Lordship, he has submitted also. That I am not denying.
Madam, what
Lordship, the difficulty is this, Lordship, keeping the post vacant. It may so happen that the other eligible candidates may also could have got the opportunity. It is absolutely beyond the scope of natural justice because, your lordship,
selection process is over.
Selection process is over. Appointment is also done.
Selection process is, give me a second. Selection process over. You have created a panel. One post is kept vacant. Now he got the certificate. He has submitted the certificate. You have not floated any new recruitment advertisement.
No.
Lordship, but the point, Lordship, the point is that for the keeping one post vacant, we are aggrieved with the situation of the fact that keeping one post vacant and granting opportunity to the petitioner to submit the EWS certificate later beyond the
suffering has already been undergone by LICI. That suffering which you are saying, this order was passed. You are saying this order was passed on
25th of
June 2024. So that suffering of not filling up the post is continuously proceeding. Now he has given the certificate, give him the appointment, madam. What is the
Lordship,
problem?
I bow down before your lordship, but the impugned order is beyond the records because it goes beyond the eligibility terms. Because the undertaking he has given false undertaking, your lordship.
Now,
Because
just a moment. Your point is it is beyond advertisement. Why?
because your lordship,
That our time finished on 1st January 23. He could not produce.
he could not, despite
So
giving
that
so much,
time could not be extended.
that despite giving so much of undertakings, he didn't apply. He applied in 29th of February. He gave the undertaking earlier and applied late. Because the acknowledgement slip that he has annexed, the stamp says it is 29th of February. That means he have applied much late. So if 4 days time, which my lord has been pleased to observe, the Honorable Single Bench has pleased to observe, only 4 days time was given to the petitioner. That is not correct, your lordship. Because that is the situation where he gave several undertakings. We have requested him several.
Which portion of the judgment according to you is ought not to have been passed by the land single?
Lordship, page 119, the 4 days time was not given. Despite giving several undertakings, he didn't submit.
119.
119, the operative portion which I have just indicated, your lordship.
So that is the submission.
Lordship, that is the observation of the court.
Court has held in your favor that you have rightly called for the certificate of 22.
That is required.
Court has held in your favor. However, court has exercised discretion in his favor because he has the present certificate as EWS.
But keeping one post vacant, your lordship.
Just a moment, let us understand. Court said that you are right because they ought to have brought the certificate of 22-23 pertaining to the financial year 21-22. So his contention was negated. His contention latest certificate, that was. Second was that this certificate is of 21-22. I am keeping you keep the post vacant for a particular period. In the meantime, if he is able to produce the same, this factum of undertaking was not taken into consideration. That is your grievance.
Apart from this, your lordship, the acknowledgement.
Internal page number 4 and 5 কিন্তু কোর্ট ওদেরকে আপলোড করেনি একটু দেখুন
Internal page 4.
So LIC cannot be said to have traveled beyond the employment. The employment.
মানে LIC ছিল 22-23 ও বললো 22-23 চাইতে পারো না, লেটেস্ট দিতে বলেছো। কোর্ট বললো না, ও চেয়েছে অ্যাকচুয়ালি এই সার্টিফিকেটটা।
দেখুন, so LIC
travel
beyond the employment notice or having
EWS was the immediate preceding year.
Internal page 4, my lord. Last.
এটা বলতে
did not come to a seat.
এটাই হচ্ছে রিজন।
He is giving the undertaking and he is not applied.
Where is your late 22nd February which certificate?
Lordship, 22nd February letter is at page. Prior to that, also on 5th February 2020, 114.
Was the 22nd February?
Page 114 and page 115.
Page 114.
114 is the one letter for 5th February 2024, requesting him to produce, and thereafter 115. This 4 days has been considered, but the undertakings and his late application has not been considered. And the post has been kept vacant, your lordship.
So in this letter, you clarified that it should be 22-23 certificate. But in your advertisement, you said latest certificate.
Latest.
Where is that advertisement page?
Lordship, that I am indicating, your Lordship, that is the page, my Lord, page 35.
Yeah.
Regarding the caste certificates, your Lordship.
Just a page.
Page 35, your Lordship. Roman 8. Caste certificates must.
37.
Page 35, Roman 8. It says that it should be in a format.
Where is that term latest?
Latest, Lordship, I don't find.
Yes, where is that?
Latest is, my lord, there are kindly.
If it is latest, your Lordship, it is on the advertisement is on 21st January and the cutoff is 1st January. So therefore, 22-23 is the latest. So he ought to have given at the.
So caste certificate of which year, that has not been mentioned in the advertisement.
Yes.
As per DOPT, your Lordship, three years caste certificate is required. That if your Lordship pleases, I can place the relevant rules. Page 35 mainly speaks about the format, the concerned authority who will be the competent one to give the caste certificate.
Full of fresh certificate. আমি 2024 যখন দিল 22-23 সার্টিফিকেটই চাইছি।
Question is, he has given the undertaking and applied late, ignoring the terms and conditions.
কত প্যারাগ্রাফ ছিল? কত? এটা 7 নম্বর প্যারাগ্রাফ।
Where is the letter of 12th June 2023?
Lordship, 12th June 2023, your Lordship, the page number
45.
45. Earlier also there are some thumb impression undertakings, page 44, 45. He has given the undertaking. Continuously he has given the undertaking, but he has not applied. The impugned order, my humble submission, is beyond the record, your Lordship.
Madam,
Lordship.
you are referring the paragraph number 118. That is the submission of the learned advocate.
119. 119.
Finding comes from second paragraph of page number 120, madam.
Lordship, 119, the observation, the reason.
No, that is not the observation. That is the submission. Just follow the chronology.
Lordship.
Maybe it has been written, but actually.
But this submission has been relied upon, your Lordship. Kindly consider, your
Lordship.
Lordship.
From page number 120. After hearing the parties and considering the materials.
Lordship, but this submission has been considered. Undertaking, the question of undertaking and not applying, misleading the authority concerned has not been taken into consideration, your Lordship.
When he was called for interview?
Lordship, he was called for the interview on
12th June 2023. It is at page 120, my lord, last portion of the order. However, in the letter dated 12th June 2020, by which petitioner was called for interview.
That is page
45.
Internal page number 4 of the impugned order.
In the stay application?
Page number 1.
Stay application.
No, where is that letter? 12 June 23?
12 June, Lordship, that is page 47. That is the annexure, Lordship.
So
45. I pray for
45.
apology, Your Lordship, page
So
45.
you appear for recruitment, not brought the 22-23 certificate.
And I am going to submit the above document within 19th June, page 45. Thereafter, medical test was also done, Your Lordship. That is page 47. Then also he has given the undertaking, but he didn't apply.
Madam, let us read the operative portion. Page number 120. After hearing the parties and considering the materials on record, I find LICI has only asked for EWS certificate for the year 2022 and 2023 based on the petitioner's family income for the financial year 21-22. Although the employment notice was published on 21st January 2023, that is during the financial year of 2023-24. Full stop. On the date of application in terms of the employment notice, the financial year 2022-23 did not come to end because it was published in the month of January. So LIC cannot be said to have traveled beyond the employment notice on having asked for the EWS certificate for the immediate preceding year, which came to an end on 31st March 2020. That means it should be 2022-23. That is in your favor. The employment notice dated such and such has to be taken into consideration, has to take into consideration the petitioner's family income for the financial year 21-22, as the financial year 22-23 did not come to an end as on 23 when the employment notice was published. So the learned single judge has said that when the employment notice was published, the financial year of 2022-23 has not come to an end. Therefore, consideration would be on the basis of 21-22. However, in the later date, by petition which the petitioner was called for being annexed at page 58 of the petition, LIC has asked for latest EWS.
Where is this
By the-
latest word?
Kindly come to page 98, paragraph 21, subparagraph 7.
What is that?
If that is not the certificate.
Why it is said? Sorry, I interrupted. This latest EWS certificate.
That is written in page 98, paragraph 21, subparagraph 7.
Yeah, just a moment. Page 98.
Paragraph 21, subparagraph 7.
This is the advertisement.
Yes.
Advertisement notice. page 98.
Subparagraph 7.
And
It is relevant, not the latest.
Relevant certificate. The latest is there, my lord. That is also
Where it
that is we are trying to find, lord, but kindly.
That is not there.
Latest is not there. Relevant is there.
Latest is also there. There are all 3 positions, my lord, where they are talking about EWS certificates. One, madam had also.
Show us.
Yes. And
This paragraph which is being read, court observe, however, in the letter of 12th June, by which the petitioner has called for interview, LIC has asked the latest EWS.
Yes, that is there, but we are finding it. But kindly come to subparagraph 7, Lord. Relevant certificate for claiming reservation under EWS. So they are saying relevant certificate. And when I, my lord, appeared before the medical, so they are saying about only one certificate.
The present writ petition has the present writ So now you have to, if they have, we have said that he has already produced
Yes,
this.
on 2nd September.
Yes.
Yes.
Yeah, just a minute.
30 December করলেন 31st December করলেন ওটেরই ডিসকাশন হবে টু এক্সটেন্ড মানে কন্টেম্পটের উপরে ইয়েস নেক্সট
Item number 7. My lord, in 7, I beg to appear on behalf of the appellant, my lord. My lord, unfortunately, his service is not yet complete, my lord. I am praying for 2 more weeks of time, my lord.
Mr. Dotto, learned advocate, appearing for the appellants. Next.
Item number 8.
Respondent numbers 2 to 7, madam.
I've got the respondent number 1.
Which for the appellate, sir?
Lordship, I am appearing for the appellant's lordship led by learned senior advocate Mr. Shaumo Mojumdar.
Where is your counsel?
Lordship, he is appearing in a matter in court number 13, Lordship.
What do you propose to do?
Lordship, I can start, Lordship. Whenever he will be available, he will join this matter, Lordship, before your Lordship.
Availability is with the court, not with the council.
Lordship, I can start, Lordship.
You will do the case?
Yes, Lordship.
What was?
Lordship,
Give
we
us-
are holders of post Lordship under the respondent bank, that is the Paschim Banga Gramin Bank, Lordship.
Just a moment.
It is a notification dated 19 December 2023, Lordship, which is a
Give us a second.
He is a time.
Okay.
জায়গার গল্প আছে
Hmm?
অনেকগুলো রুলস টুলস জায়গার গল্প আছে ওগুলো বলছে না
You appear physically and produce the rules. Where are the rules which have been referred to here?
At page, my lord.
সেকশন 5 থেকে
Lordship, page number 84, Lordship.
83 onwards, my lord.
সেকশন 5 থেকে ডিসপ্লে
Page number 84 of the read petition, Lordship.
Your section 5, I'm keeping it on there. Ask your senior to appear along with all the records. You know.
Nine days. এটা হচ্ছে CAN 1 of 2024. This is an application under section 5 of the Limitation Act filed by the appellant praying for condonation of delay of 9 days in filing the instant appeal. Stop that. On perusal of the entire materials as placed before this court, and after hearing the learned advocate for the appellant and the respondents, we are satisfied that the appellant is successful in explaining 6 days delay in filing the instant appeal, 9 days delay in filing the instant appeal. Accordingly, the delay in filing the instant appeal is hereby condoned. Stop para. Consequently, can 1 of 2024 is disposed of, is allowed and disposed of. Stop. এবার appeal চলে আসুন. Let the instant appeal along with can 2 be listed on such and such date under the heading
application.
Stay as can 2 be listed under the same heading on such and such date in the daily supplementary list.
18th December.
18th December.
Fine.
Yes, next.
এই তোমারটা বলে দাও তাহলে ট্যাগ করে বিপ্লব রাষ্ট্র
মেইনটা তো আমাদের I appear on behalf of the appellants.
Service has been affected.
Yes, my lord. There was regular appearance on behalf of the Gorkhaland Territorial Administration, Mr. B.P. Subba, and also on behalf of the state.
GTA is the main answering respondent.
Who is the answering respondent?
GTA.
The Gorkhaland Territorial Administration. At their instance, yes, they have appeared. They
are not represented
today. Today, I don't find Mr. Subba here. But, my lord, this is an urgent matter, my lord. It's been pending for quite some time.
Urgent matter.
My lord, it is. My land, my lord, has been forcibly taken possession of. They could not show, my lord, any scrap of document to show that it had been acquired.
On your prayer, matter was adjourned, Mr. Banerjee.
That is because they could not have, they did not produce, my lord, the valuation certificates which were asked of them by court. Mr. Subba, my lord, had taken some time to produce the certificate.
It will be in the supplementary list on 18th.
18th.
Order করতে হবে
সুবিধা
লিখে তো Banerjee
do the appellant and the respondent state are represented today, but the respondent number
I appear for the respondent number 4.
Hearing?
Yes, my
Hearing
lord.
matter?
It's a hearing, my lord.
Mr. Mitra, come next monthly list.
My lord, very well. No, my lord, will it be your lordship's pleasure?
Regular bench, no?
My brother would be there till Friday. Again the bench
Friday,
changes.
1 or 2 hours.
Again the bench. My brother is not wanting to stay with. I said Friday. He specified that only for 1 or 2.
No, it's not so. And Chatterjee joined.
Next monthly list.
My lord,
Yes.
may I seek one indulgence instead of the next monthly list, sometime in January, but if your lordship's fix a date, any date, my lord.
Let it appear in the monthly list. It will be fairly at the top. If it is not reached, you remind.
Very
Yes. 11. Who is for the appellant?
I appear for the appellant, my lord.
You're for the appellant. What is the scan?
Scan is a stay application.
You have served?
But I have served. This matter was substantially heard, my lord. Mr. Pani is appearing for the writ petitioner respondent.
All right, come next month. Yes, next.
Lordship, for 12, I am for the appellant. Lordship, in this matter, Mr. Dhol is appearing. In terms of the earlier order of the coordinate bench, Lordship, the paper book is ready. There is an earlier order of the coordinate bench dated.
What is the...
Lordship, I am for the respondent.
Lordship, this is regarding fixing of the seniority of the appellant, Lordship, wherein...
Lord, I am for respondent
For the respondent,
in this
Lordship.
matter for Punjab National Bank. It's a hearing matter, my lord.
Lordship, the council is not available to us, praying for an adjournment, Lordship.
All right, next monthly list. Yes.
But there is a direction, my lord, to file paper book.
You have filed it, na?
Yes,
No.
yes. We have received copy.
Prepare legible copy.
15, sir.
Yes, yes. You have filed the paper book, na?
But, my lord, that was filed.
Hmm.
But some of the documents of that paper book was not legible.
Right.
So, my lord, I was directed to refile it.
You file the entire paper book or document?
Entire paper book containing the legible copies.
Very good. Now it is with you.
Yes.
We will hear it on.
Lordship, I am praying for an adjournment. The council is not available to.
Next.
I appear on behalf of the writ petitioners, respondent number 127.
Yes.
I am for the writ petitioner, respondent number 1.
My lord, paper books will lie with us, my lord, in the previous.
Keep it with you. You have served your other side.
Yes.
Very good. Next day we shall take it. Yes, next.
13. I am for the writ petitioners, respondent number.
We are already loaded with files. That is why we are requesting you to keep it with you.
Who is for the appellant?
Mokaram Hussain possibly is for the appellant. I am for the respondent.
What is the issue?
The issue is the writ petitioners. They are the employees of Diden Mollabhum Gramin Bank. Now, initially there was a direction of the Honorable Apex Court to constitute a committee for fixation of pay scale of the officers of Gramin Bank at par with the sponsor bank. Now, in terms of the Honorable Apex Court, a tribunal was formed and tribunal suggested certain recommendation based upon which the pay scale of the Gramin Bank officers were fixed at par with the officers of sponsor bank. Now, it was implemented. After it was implemented, payment was released in favor of the writ petitioners. The then Mollabhum Gramin Bank, they issued a circular contending that the fixation which was done, it was a wrong fixation, and they wanted to refix it and recover some portion of the amount already paid to the
Was it hard? Was it hard after filing of paper books?
No, Lordship, after filing, it was initially dismissed for default and application for recalling was filed after.
You give a notice to your other side. We will
On the
take it
last
up.
occasion, he was present at his request.
Who is
Mr. Mokaram Hussain.
All right. You give a notice. We will take it up on the next.
Lordship, kindly fix it because my clients, they all are senior
Take it up.
citizen.
We'll take it up in
Lordship, kindly fix it. We will indicate and serve a
next
notice.
monthly list you serve. দেখি ফাইলটা দাও দেখি কি অর্ডার আছে
The last occasion he appeared and he submitted.
No one appears on behalf of the appellants, though Mr. Shah, learned advocate, appearing for the respondents. Is present.
I am for respondent number 1 to 7.
All the respondents.
No, Lordship, there are National Agricultural Bank. I am not representing them. 8, 9, and 10. They are the
list them for the respondent numbers.
1 to 7 writ petitioners.
For the writ petition, for the writ petitioners, stroke respondent numbers 1 to 7 is present. ঠিক আছে? To give a further opportunity to the appellants to appear, comma, the matter stands adjourned, list the matter for further consideration. The combined monthly list of January 2025. Mr. Shah is directed to intimate this order to the learned advocate who entered appearance on behalf of the appellants and to file an affidavit of service on the return and to file an affidavit of service.
May I pray? Let the matter will remain its position because my.
It will remain in
Lords. I'm grateful.
We're coming back after 10.
I'm good.
Yes.
My lord, I am for the petitioner.
পেপার বুক আছে
I am for the appellant.
পেপার বুকটা দাও এটা দেখি অর্ডার শিট গুলো একটু দেখি
Which order is under challenge?
My lord, order dated at page 37, 31. Order dated 5th May 2016.
You are the read prisoner before the trial court.
Yes.
তার থেকে একটু দেবে লোক এসে বসেছিল
Impugn?
Order dated by at page 30, 31, 30 and 31.
Give us a second.
Page 30.
27 to 30.
What did you challenge in the writ petition?
My lord, come to page 2 of the paper book. Page 2 of the paper book.
That is the writ petition. We are
Yes.
asking what did you challenge?
How you are agreed?
My lord, I had two prayer. There is non-action on the part of the respondent authority in not allowing the petitioner to release the service benefits, as also not allowing him to join in the service. He was on temporary leave for his illness. After recovery from the illness, he was not allowed to join. And my lord, repeated charge sheet was there, one after another. So no access was given in the hearing. And he was a very
You
expert.
accepted the punishment.
I don't accept punishment.
Then why did the learned single judge record in page 31 or say that entire exercise of releasing upon the petitioner accepting the order of punishment?
By leaving prisoner free, second paragraph, page 31.
Yes.
Exercise of releasing the entire payment. You petitioner upon the petitioner accepting the order of punishment should be completed within 6 weeks from date. It means that at the time of hearing it has been stated.
No, this was the order. Order given by the single judge. The exercise of the releasing the entire payment due to petitioner upon the petitioner accepting the order of punishment should be completed within 6 weeks from date. In the event the petitioner does not cooperate by furnishing the relevant documents,
it means that the order of punishment was not challenged at the time of hearing. Why the learned single judge will record this?
my lord, that is under challenge before the honorable court. I did not submit so because I had two prayers. One, my due salary was there, and also I specifically prayed kindly come to page 13 of the prayer portion of the writ petition.
Yes, we have seen.
Page 13.
First prayer is disbursement of the service benefits. Another is to join the.
To allow the petitioner to join his duty as mechanical helper forthwith.
It was disposed of at the motion stage without calling for affidavit.
It was?
Without calling for affidavit, the writ petition was disposed of.
Yes, by single order.
Affidavits are not exchanged.
No. And my lord, there are some lacuna in the application.
I prepared a supplementary affidavit which was granted leave by the Honorable Court in the appellate by Justice Sumit Talukdar. I annexed that at page 39, sorry, 38 onwards. 38 onwards of the paper book.
58.
No, 38 to onward.
You were absent from your services since 1993. They issued a charge sheet and a final order of punishment.
Yes.
So why you are not saying the actual things? You
No.
were punished, you have said in paragraph 7 of your writ petition at page 7 of the paper book that they issued a charge sheet on 29th January 99.
99.
And thereafter inquiry officer filed his report.
17/10/2000.
Yes.
Yes.
No, it was found that you are absenting since 17th of December 1997.
Yes, Mala, come back to paragraph 5. Come back to paragraph 5. At page 5. Your petitioner states that for better treatment and due to his illness, the petitioner on 2011-97 duly made an application for leave on and from 7/2/97 to 30/2/97 from the leave granting authority, and same was allowed. Thereafter, paragraph 6.
Where is it allowed? P3?
Allowed.
Where is P3 that
Next
it was
P3.
allowed? Then why was the charge sheet issued?
My lord, there is the claims on S. My lord, if my lord read the paragraph affidavit of page 38 onwards.
This is an application for leave. Where is the order granting you leave? Page 19A is the application for leave.
Yes.
P3, annexure P3 at page number 90. Legible. Oh, you have given the legible copy. Yeah, application for
Leave. But below of the application, patient again came
Did
some
you challenge-
differently referred to
challenge the
checkup
final
and
order of
opinion.
punishment?
Leave. Leave. Page 18A.
You were removed from service.
P3. P3.
You were removed from service on 17th December 17th
7/12.
October 2000.
Yes.
Then what did you do?
My lord, my client felt in a serious financial hardship. He was asked.
Challenge this order. Did you challenge the removal order?
This was challenged
23
basically in
is the
this
removal order.
application, but that was challenged in this writ petition. But due to poor drafting, maybe it could be materialized. That is the reason I filed the supplementary affidavit at page 38 to onwards, giving details all.
You did not challenge. You
Before the
did
writ
not
court, you did not
challenge.
challenge.
In your prayer also, you did not challenge. Your removal was in the year 2000.
2000.
So you filed the writ petition after. Writ petition was filed
15.
after 2000 removed. You filed the writ petition 2015. After 15 years.
15. My lord, what I've been said, that the client was very poor and suffer financial tendency. He
There is
traveled.
nothing in the matter.
My lord. He repeatedly visited the office. They asked, you will come.
Not
And
create any
waited.
right in
Waited
your-
after
Now
waited.
tell us, did you get when was your retirement date?
Then date expired in this
You are not
20.
sure. See, you
Sure.
have no contact with your client.
My lord, one thing I do. Now I telephone. My lord,
When was his date of superannuation?
this is this year. This 28th March, something like that. And by usual course, he has retired.
20th March
March
2024.
24 or my lord 20 August, I cannot remember. This year.
So
This
in
is definite this year.
2024 he has retired.
This is definite.
So your appeal was filed in 2018.
2018, yes. 2018.
Why didn't you tell the court before the appellate court
My
that
lord,
they are not paying me the dues?
my lord, in 24 the due has been given cleared. They have been paid. In this 24 the due has been paid. The due
Dues have been paid.
the gratuity and the various salary has been paid.
So
But from 15, but his removal was fully illegal and
did not challenge. Now these dues you have been paid in 2024.
24.
Then nothing remains in the matter.
No. My lord, the areas, no, my area salary has.
Numbers for passing of the charge sheet, passing of the finding of the disciplinary authority, passing of the finding of the appellate authority. Nothing has been done. What can be done?
My lord, but the area salary is there. His after removal, illegal removal salary has not been paid. Only the last 2-3 months.
Removal, how can salary be paid? How can salary be paid?
Unless
My lord, may I pray one thing, my lord? I have telephoned today my client. He wants to come back day after tomorrow. Can we fix on 4th? So I can come whatever remains, and definitely I'll complete. I have served the copy of paperwork, etc. on the state advocate. He's not coming. Kindly make it on 4th.
Who is appearing for this state?
Mr. Oyan Banerjee, I telephone you also, and just after serving, the copy.
No, Oyan Banerjee is appearing for transport also.
Yes. On the last occasion he appeared.
Is he appearing for the you were appointed to the post of a driver?
No, mechanic helper.
Helper.
Mechanic helper. I had some competence. I was forced to go to attend the various times. Even I suffered injury.
2020, 2000. You were dismissed in 17th October 2000. 2000. So you have not challenged that order. Dues you say have been disbursed. So there remains nothing in the matter.
My lord, I have stated on affidavit in paragraph 38 onwards for
Why
clarification.
should we go into that? When you have not challenged the order of dismissal, removal, why should we go?
My lord, let me.
Client coming.
Bankura, day after tomorrow he will come. He will come and sit on own hearing on his own high. Because it's a transfer bill. I came later at the paper was prepared by me. If it was prepared by me. Can you fix it on 4th or 4th December?
Heard Mr. Mandal and advocate appearing for the appellate. Stop. No one.
Can application is for
Substitution application, the appellant died.
Within time.
within time, ma'am.
Hey, no.
Kindly give a direction to that so that a paper book can be served upon me.
Paper book already filed, my lord.
It was not served upon me, my lord. Maybe filed.
এই ক্যানটা কোনটা গো?
Two copy of the paper যেটা স্যার হয়েছে
ক্যান নাম্বারটা কত? হ্যাঁ?
2019
2020 আনিয়ে নিয়ে অর্ডার করে দেবো, একটু দেখে নাও, দেখে নাও। You have given a copy to him?
my lord, we have
Well, he was served to the department. I was not given to the copy.
sir 19 I have served my lord.
Hudev Chatterjee appeared, Mr. Roy Choudhury was not there.
I will serve again my lord.
What is the matter? Disciplinary proceeding?
Disciplinary proceeding, dismissal from service my lord.
Dismissal.
Dismissal from service. He has already died my lord. Monetary benefit that is his wife, daughters and son is claiming.
Next month the list রেখে দেবো, substitution টা allow করে। কি পাচ্ছ না?
অর্ডার করি।
আনিয়ে নিতে পারবে না? হ্যাঁ? তাহলে ওই ক্যান টু করে দিয়ে দাও। অ্যাপ্লিকেশনটা না আনলে অর্ডারটা সই করতে পারবো না।
না ওটা রিস্ক হয়ে যাবে। একটু টাকা ট্যাগ হোক তারপরে করুন। নাহলে ওদের কাছে কপি নিয়ে অথেন্টিকেট কপি করে ওটাকে পার্ট অফ দি রেকর্ড করে করতে পারবে। Okay.
All right, it is understood he won't, substitution there is now, we will allow, but the application is not here. It will retain its position and appear in the monthly list of January.
অর্ডার করে দেবো?
And in the meantime,
করে দেবো স্যার? এরকম লিখে নিন বাবু। It is reported.
না ট্যাগ করতে বলো না, তাহলে এসেছে বলে করে দিতে।
আপনি আনিয়ে নিন।
Do you have a copy of substitution
Yes,
application?
sir.
দেখে নাও না।
তাহলে সেটা নিয়ে করতে পারি। তাহলে ওটার বেসিসে করে দিতে হবে। অথেন্টিকেট কপি করে নেবে?
না ওরা আনিয়ে নেবে, তুমি অর্ডারটা করো। আনিয়ে নাও, তুমি আনিয়ে অর্ডারটা করো।
ফাইলিং ডেট রয়েছে। Who has died?
Appellant has died my lord.
Sole appellant.
Sole appellant.
Leaving behind.
Wife, 2 sons my lord and 1 daughter.
Where are their particulars?
তুমি না
They are all major my lord.
Where are their particulars, ma'am?
Well, in the cause title, there is Tulsi Singh, his wife, Niliba Singh, daughter.
Yes. Can prove up 2023 is an application for substitution of the legal heirs of the appellant Sudhir Kumar Singh, since deceased, who according to the petitioners died on
27 December my lord.
December 27, 2020. Stop. The application is filed within the period of limitation. In view of such, prayer for substitution of the legal heirs of the deceased appellant, particulars of whom have been given in the cause title of the instant application, is hereby allowed. The office is directed to carry out the necessary correction in title of the instant appeal by deleting the name of the deceased appellant and by incorporating the names of the substituted appellants. Forthwith.
application disposed of.
With the aforementioned observation, Can 2 of 2023 is thus allowed and disposed of.
Release the matter.
তাহলে এটা অ্যাপিলে আসুন।
মানে direction to serve the copy.
This matter in the month list of next month list in the next month list of January 2021 under the heading under the same heading.
Miss Neogi is requested.
Learned advocate for the appellant is hereby requested to serve a copy of the paper book to the learned advocate for the
Here for all, Mr.
learned advocate for the respondent, preferably within 7 days from today.
Give a copy to him. We will hear it on.
And for the respondent restriction.
What is the application, Mr. Majumdar? Application can
Stay application,
no paperwork.
no paper book.
Mr. Majumdar, what is the nature of the impugned order?
Hello?
What is the nature of the impugned judgment? What direction has been passed?
My lord, I was punished 20% cut from the pensionary benefit. That was set aside.
That was set aside. That is the subject matter of the instant appeal.
Have they used opposition, Mr. Majumdar?
Yes.
না এখানেই হবে দেখি দেখি application opposition till issue apprehension consent
Interim training.
stay দিয়েছে তো?
দিয়েছে আচ্ছা। অপোজিশন তো ওনারা দেবেন।
They have given the reply
No, my lord.
till disposal
You have
appellation
filed your appeal in opposition.
have consequence.
I have filed affidavit in opposition.
Opposition আছে গো এখানে? হ্যাঁ আচ্ছা আচ্ছা।
কবে থেকে পড়ে রয়েছে মমতা
ডেট ফিক্স করে দিন নোটিশ সার্ভিস করতে বলুন।
চল দুজন আমি শুনে নি
হ্যাঁ অ্যাপিল নেই তোকে কাকে শুনবে?
on the prayer of অনেক আগে 2019-এর থেকে চলছে।
Mr. Chakraborty and Mr. Ghosh appear on behalf of the appellant.
My lord.
Hearing a date fix করে দিন।
কতবার ফিক্স করে বলো তো একবার এই লিস্টে দেবে আবার ওই লিস্টে দেবে আবার এখান থেকে পেয়ে চলে
আমি অ্যাপিল ডিসমিস করি। এটাই ভালো।
এটাই
মিশনের মামলা। তুমি মেনশনটা দিয়ে দিন।
না না এখানেই দিচ্ছি
আজকে করে দেবেন? হ্যাঁ
কি হবে আবার সাবসে আবার রেস্টোরেশন নিয়ে আসবে। What is your age now?
My lord, I retired from service on 28th February 2012.
Benefits have been disbursed? No.
Nothing.
Why the remaining benefits ought to have been disbursed?
No, nothing.
It was a cut from family.
20% cut from the pension.
20% cut.
So after cut, it has been disbursed.
Well, after cutting, no disbursement.
Not disbursed.
No.
Pension not disbursed.
No disbursed.
Even after cutting.
Then what you are doing for so long? You could have come up with an application.
Because
your client does not want the money.
The court has passed the stay order. That is the difficulty.
For vacating the same, you should have come. Person retired in 2012. We are in 2024.
He is not getting pension.
Pension. Lordship, kindly go through the order passed by the London trial court.
That is at page. That is at page.
Consider each and everything, my lord.
আচ্ছা মেমোতে আছে।
They have filed a section 5 application.
Section 5. Section 5.
Yes, my lord. 52 days delay.
That has not also been disposed of.
My lord, I do not know, my lord, the whether
interim order was granted. Interim order granted. So must have been. Can 8622 দেখো তো নিশ্চয়ই ডিসক্লোজ করবে।
Yes, it has been disposed of on 18/9/2019. Note it, 18/9/2019 it has been disposed of. And এটাই কি অর্ডার এইটার জন্য appeal disposal of the appeal appellants have not released the inferior information.
আরো ঘুমোচ্ছে 5 বছর ঘুমোচ্ছে
বুঝুন কি বাবরি এটা কি অর্ডার হয়েছে
They have annexed the order, my lord, in the stay application.
Give us a second, sir. করেছে ভাবিয়ে ভায়োলেশন অফ রুলস এর গ্রাউন্ডে টেকনিক্যাল গ্রাউন্ডে বেরিয়ে গেছে ডিসমিস করে মোটর স্ট্যান্স
ডিসমিস করবো পারপাস সার্ভ করবে না আবার ডিসমিস
চেক করে দিন Consequence of benefit
ফাইল করেছে রিপ্লাই সেপ্টেম্বর
নোটিস করে করাটাই ভালো।
দেখো এখানে আমার দেখো এক্সপ্লেন দি পিরিয়ড অফ কিসের জন্য ডিলে আর এক্সপ্লেন করবে, এটা তো অ্যালাউডই হয়ে গেছে।
হয়ে গেছে, হ্যাঁ।
দেখায়ও না জজ স্যারদের, সমাদের স্যার তো অ্যালাউ করে দিয়ে গেছে। এখানে বুকিং অর্ডার দিয়ে গেল উইদাউট ফাইলিং এনি, সেকশন 5টা অ্যালাউ।
হয়ে গেছে,
কোথায় পাবো অ্যালাউ? সেকশন 5 অ্যাপ্লিকেশনটা তো হচ্ছে তোমার এই যে তাহলে আবার এখানে কেন বলছি 8622 আবার ঢুকিয়ে দিচ্ছি। ওই 8622টা যেটা ডিসমিস করলো অর্ডারটা দেখাবে
আবার হয়েছে এটা একটু
অন দি প্লেয়ার কোর্টকে
বলেনি এটা ডিসপোজ অফ হয়েছে।
in order to use for filing. তুমি দেখো রেকর্ড এখানে কোনটা এসছে আমাদের কাছে,
এই অর্ডারটাকে রিকল করে নিচ্ছি আমরা।
না আচ্ছা কত নম্বর 16, এটা তো ক্যান টু এক্সিস্ট, ওটা দেয়নি তার মানে ডিসপোজ ছেড়ে দাও।
এটাকে একটা এরিয়া একটা ডেট রাখুন, একটা টুল মেনশনের মতো নোটিস করতে হবে। None appears on behalf of the
fits or not, how much, this is not 20% cut, this is on the basis of rule 9. Proceedings were initiated subsequent to the retirement of the petitioner.
Your lordship, division bench judgment, single bench judgment is there.
No, Mr. Majumdar, that is where proceeding initiated against the petitioner after the retirement. It is not such a case. This is a case where proceeding initiated prior to retirement. But in the meantime, you retired.
Yes, they have allowed me to retire from service.
Yes.
My Lord Justice.
On that ground, the petition was allowed.
Yes.
But
not
you,
only
Mr.
that,
Majumdar,
there is a provision in the my Lord rule that if you do not allow me to retire from service, you may keep me under suspension. And during the suspension, but they do not place me under suspension.
That has been noticed by the learned single bench.
Single bench.
What I am on, Mr.
Not only that, delay caused, inordinate and wanton delay is caused fully attributable to the respondent. Learned judge held. 2013, my lord, that's landed single judge, my
Mr.
lord.
Majumdar, take instruction.
My lord.
Because there is a stay order passed by a coordinate bench in respect of the remaining consequential benefit. Please ascertain from your client whether he is getting 80% of his pension or not.
My lord.
Please ascertain in the meantime.
Please ascertain and come back and tell us. And you inform your other side also, we will fix on that date or we can dispose it of on.
But if it is to be mentioned, then your lordship kindly give me earlier date. I shall communicate the matter in course of.
We will fix on that date. On that date, we will fix a date of hearing. What is it?
Because earlier date, if your lordship give me, I shall communicate the same.
It cannot be done, I think.
Next week.
17th করে দাও 17th. Yes, next.
My lord, I am appearing for the appellant writ petitioner, my lord. This matter relates to non-publication of the combined merit list, my lord. My writ petition has been dismissed. My lord, I am a candidate, my lord.
Delay and everything allowed.
Yes.
Nothing is showing pending.
Who is your other side?
My lord,
This matter, I am for the respondent.
All right. Any interim orders have?
No, my no. My lord, I participate. The short fact is,
You show us the order first.
yes, at page 131, my lord. This is dated 28th of September 2018, my lord. Page 131. May I place, my?
Give us time. We will go. Yes, Mr. Mukherjee.
Yes, my lord. Now, my lord, the learned single judge, my lord, at page 134, your lordship will find the second line. The learned single judge was pleased to observe that the petitioner has not been able to canvass any illegality on the part of the respondents in the process of selection. My lord, I shall demonstrate that there is one procedural impropriety, my lord, that the respondents never published the combined merit list. Although in their affidavit in opposition, my lord, they have referred to a combined merit list handed over by the Indian Institute of Technology. The selection was held by the Indian Institute of Technology. My lord, kindly allow me to straightway, my lord, refer to this affidavit in
belong to unreserved category.
my lord, I am a general category, unreserved category. Yes.
Reserve or unreserved?
Unreserved, my lord.
Unreserved.
Unreserved. Now, my lord, what the authority published, there are total 25 vacancies. The selection process was initiated by the West Bengal State Electricity Distribution Company Limited. There are total 20 vacancies. Your lordship will find
20 or 25?
25, my lord. Page 71. My lord, this is the advertisement dated 1st of May 2007. Kindly consider, my lord, serial number 3 box, assistant engineer, IT, computer science. My lord, under the box WBACDCL, that is the distribution company. I'm sorry, ma'am. Under the distribution company, there are 20 vacancies. And my lord, for the transmission company, my lord, for assistant engineer, there are 5 vacancies. So the total vacancies was 25, my lord. Now,
Both
thereafter,
of them are parties.
my lord,
Both the organizations.
my lord, the company is the party. My lord. Under it, my lord, the
company is WBECDCL. Grievance is against WBECDCL. That is restricted to 20 vacancies.
Now, my lord, at page 73,
73.
my lord, I was directed to appear
in the
for an interview. Yes. Now, my lord, after the my lord, completion of the written test, my lord, page 74 was the combined merit list. So far, the my lord, this is before the interview, page 74.
Now, first show that in the advertisement there was any provision for combined merit list.
My lord,
Page
there
71.
71, there was no such combined merit list. There is nothing has been indicated.
All right.
Now, my lord, I participated in the interview. These are all admitted facts. Thereafter, my lord, kindly consider page 78.
After 73, you have shown us
78.
No, 74, the combined list you said.
What
Yes.
is 74?
My lord, 74 is the total, my lord, your lordship will find serial number 7, Ashish Pan, the appellant before your lordship. This is after the written test. The selected candidates' name were published, my lord. My name was also there and I was directed to appear before the interview.
This was published by WBECDCL.
Yes. Yes. Then, my lord.
So it is admitted position that you have been called for interview.
Called for interview.
Very good. What happened thereafter?
Thereafter, my lord, page 78, they published a list of only 20 candidates.
List of successful candidates.
Successful candidates. The final list of successful candidates against advertisement number dated 1st of May 2007, list of successful candidates for appointment to the post of assistant engineer. Your lordship will find the next page. 20 successful candidates' name were published.
Your name did not feature.
Certainly not, but my lord, the combined merit list, my lord, your lordship knows, my lord, combined merit list includes, my lord, the names of the unsuccessful candidates. I do not know where is my position. So I wrote a, my lord, letter, my lord, to the...
Sorry, combined list will
Combined
incorporate the names of unsuccessful persons
Yes.
also?
Because, my lord, the combined merit list, my lord, includes the selected candidates as well as, my lord, the unsuccessful candidates.
Where from you are arguing this?
My lord, this was, my lord,
this argument of yours, non-preparation of combined list was a failure on their part. So you show us anything that...
my lord, your lordship kindly consider...
we shall not stop you. You proceed on your...
Yes, ma'am.
So you showed us page 79, 78.
My lord, kindly consider page 86 thereafter. Kindly consider page 86.
Page 86.
My lord, this is a letter.
Just.
I'm sorry, my lord. My lord,
Now you are wanting us to page 86.
86 at page 87. I wrote a letter to the managing director, chairman and managing director. Kindly consider paragraph 7. I requested them to publish the entire panel.
Yes.
Now, since my lord, nothing fruitful had happened, my lord, I filed this writ petition.
Yeah,
No,
just a moment.
I'm sorry.
Yes, then you want us to look into?
Page 86, my lord, my letter.
Yes.
Requesting the chairman and managing director, my lord, to publish the entire panel. Page 86 is a letter dated 25th October 2009. Relevant is at page 87.
Yes, please.
My lord, paragraph 7, that this unnecessary delay in the publication of the said panel list hampering my client's education and future, that my client is mentally shocked and harassed for unnecessary killing of time. Now, my lord, in spite of this, my lord, no reply was given. I filed a writ petition, and my lord, in connection with this writ petition, they used an affidavit in opposition, which is at page 98. My lord, relevant is paragraph
earlier round of litigation or in the
no in this present appeal. My lord,
they are coming.
I'm sorry, page 100.
Page 100.
Yes, my lord. My lord, paragraph 4, Roman 1, notification number such and such dated 1st of May 2007 was issued in leading newspaper for recruitment of some officers, which includes 25 numbers of assistant engineers. IIT Kharagpur conducted total recruitment process, including written test and interview, and handed over the merit list. Kindly consider this. The merit list to the authority of the WBSEDCL. In the above notification, it was clearly indicated that selection will be made on the basis of performance at written test and interview, and filling up of declared post will be subject of compliance of government reservation rules in force such and such. Then 4 is very important. For that post of assistant engineer, number of notified vacancies under WBSEDCL were 20, and for WBSETCL it was 5. Out of the merit list received from the IIT Kharagpur, a pair of panel were made consisting of 20 candidates for a WBSEDCL and 5 candidates for WBSETCL for filling up notified
Now,
vacancies.
who called you for selection was conducted by
IIT.
IIT. So you were written test you participated?
Participated, I was
You must
selected.
be successful, called for the interview by IIT.
My lord, the selection body, my lord. At that point of time, I was not under any knowledge that the IIT was holding the selection process.
Interview letter was issued by
that was, my lord, at page 73. That was issued by the authority, my lord.
They were conducting the entire
They entrusted IIT, my lord. They entrusted IIT. Now, your lordship will find paragraph Roman 4 that the Indian Institute of Technology, Kharagpur, my lord, prepared a merit list, and my lord, from that panel, my lord, they, my lord, published the first 20 names. First 20 names. There is no dispute. So I accept this, that Indian Institute of Technology, my lord, certainly they must provide the panel which is called, my lord, the combined merit list. That means selected or, my lord, the first M panel candidates, first 20 M panel candidates, and thereafter the other names of the other candidates, my lord. Suppose the first M panel candidate refuses to join, then the 21st or 22nd M panel candidate will be given a choice. Now, your lordship will find paragraph 8.
No, don't skip paragraph 7.
Yes, my lord. Paragraph 7 is also, yes, yes. I'm grateful.
Very relevant.
Actually, 5 set of panels were prepared after following norms of reservations, and appointment orders were immediately issued in favor of the impanel candidates to fill up the...
Read from paragraph 5. Na?
Very well, my lord. Let me read from paragraph 5. On receipt of the merit list against the respective category from the IIT Kharagpur, appointment letters were issued to the eligible candidates as per above panel, prepared strictly as per merit list of IIT Kharagpur, observing reservation rules. Some of the appointees did not join or resigned after joining. To fill up such vacancies out of the notified vacancies as stated above, further sets of panels were made from the said merit list.
You did not find place.
I did not find.
Very good. Now read.
Yes, paragraph 7, my lord. Actually, 5 set of panels were prepared after following norms of reservations, and appointment orders were immediately issued in favor of the impanel candidates to fill up the resultant vacancies due to non-joining or resignation as stated above. The last appointed general candidate in the post of assistant engineer was Muhammad Minarul Islam. His rank in the said combined general merit list was 25, whereas Sri Ashish Pan's rank was 43.
It is on affidavit, sir.
It is on their affidavit.
It is on affidavit.
It is on affidavit.
So it is to be treated as an evidence. They stated that you being an unreserved candidate secured rank 43, whereas the last successful candidate
25.
The general rank is 25.
25.
So why the court will disbelieve?
No.
In absence of
Question is, my lord, question is, before the court, they fail to produce the combined merit list. They must substantiate it, my lord.
You finish.
Very good. The last appointed ST candidate in the
Affidavit
post
is not required. SC
not
we are
required, not required. Therefore, my lord, and one later, my lord, I shall
Now, clause 10, after having
filled in the notified vacancies as above, the competent authority of the companies decided on 19th May 2009 not to make any further appointment from the aforesaid merit list. Now, my first submission,
next one. Please.
Petitioner was a general category candidate and his position in the merit list was 43, whereas the last general category candidate recruited strictly observation of the government was Muhammad Munirul Islam, securing 25th position. And by this, my lord, they said that they have, my lord, followed the 100-point roster.
Yeah.
My lord, now, my lord, my first submission before your lordship is that, my lord, in the pleading, they said that my position is 43 and there are 25 vacancy, therefore I do not have any chance to get to be appointed. But, my lord, the combined merit list, my lord, it is incumbent upon the employer, my lord, that, my lord, to substantiate their pleading with, my lord, annexing the relevant documents. My lord, apart from other things, my lord, I am not saying that your lordship will disbelieve WBSc DCL, but the question is, today as a candidate, even I am an unsuccessful candidate, my lord, I have a right to see the combined merit list. My lord, this is not my word, my lord. The Honorable Supreme Court, my lord, the Honorable Apex Court, my lord, laid down this law on this issue. Now, what they have annexed, my lord, admittedly, they have not annexed or, my lord, produced, my lord, the combined merit list which was prepared by the IIT. What they have annexed is at page 109. My lord, the first box, I'm sorry, my lord. Page 109, my lord, it is part of their affidavit in opposition.
So the combined list which you are saying, after completing the written and interview, the combined list was sent by the IIT to the authority. Now, on that basis, they published the first list. 6 persons did not join, so they brought the second list. Then again, some non-joining maybe for that.
Yes,
This way it
yes, in
continues
this way,
5 times.
in this way, in this way.
Now, Mr. Mukherjee, how does this action prejudices you? Do you ease your contention that I have secured more marks than the last
No,
panel?
my lord, my first thing is, my lord,
Where
what is my legal right?
We understood that for non-publication of the combined list, assuming this is accepted by us, what prejudice was suffered by?
My lord, today I have only one legal right, very limited legal right, being an unsuccessful candidate.
To see a combined list?
To see a combined list.
Show us an authority
Yes.
on that. Or you complete and show us the authority.
My lord, I shall only place 2 documents. Nothing.
Yeah, yes. No,
My lord,
no,
page
you-
109 is the only document the authority, my learned senior friend, my lord, produced. This is
109.
109, part of the affidavit in opposition. My lord, the first box is for WBSETCL. Your lordship will find names of 5 selected and thereafter appointed by the authority. Then the second
Page
panel.
109.
Yes, my lord.
First is WBSETCL.
ACTCL, transmission company.
There were 5 vacancies.
5 vacancies. So the first 5 names, my lord, your lordship will find.
We got it. Now,
Yes. Now they were appointed. Some of them, my lord, did not join. Then second panel, third panel, no names. Then third panel, there is one Moumita Sarkar. Then fourth panel, no names. Fifth panel, Minarul Islam. So by this, my lord, they appointed 5 candidates. Then for WBSETCL, the next box, my lord, your lordship will find in the first panel, my lord, there are 20 names, as my lord, I have shown at page 73.
yes.
Then second panel, there was no name. Third panel, my lord, from the combined merit list, my lord, they picked up 2 names, Sudipta Chatterjee, Vishnupada Rohidas. Then they published another panel, namely fourth panel, Sanchari Sen. And in the fifth panel, my lord, they published names of 2 candidates, and those were appointed.
So the last person
Nivedita Ghosh.
Amit Borua
Against-
against reserved category. Amit Borua is against reserved category and Nivedita Ghosh.
No, he is general.
He's general.
Reserved.
He's general.
So what was the marks obtained by the last appointed unreserved candidate? That is by Srimati Sudipta Chatterjee.
My lord, for
62
WBSETCL, that was 59.24, Minarul Islam.
You did not apply for ACTCL.
No, my lord, it's a combined, my lord.
Oh,
I
it's
can
a
be
combined.
appointed even ACTCL also. So the cut-off mark was,
এটা ওই রোস্টারটা ফলো করে এভাবে লাগিয়ে
yes.
No, for the all right, the ACTCL, WBACTCL last candidate 59.24, and the last candidate in WBACTCL
That is, my lord, Nivedita Ghosh, 60.5.
Her rank was
Rank is
21.
21. Rank 21.
21.
So in the first one, the rank of Monirul Islam is 25.
25.
What is the impropriety, sir? That I cannot.
My lord, there is only one impropriety, my lord, that
Nivedita
Nivedita
Ghosh.
Ghosh, ও তো 21 নম্বর rank আছে।
No, this rank is for, this was a combined selection.
my lord, that is
No,
No, not combined
that,
selection.
that
not
is
a
the
combined selection.
No, no.
my lord, that is the
You
first thing
applied
is
for WBACTCL.
Yes.
well, the first thing is in their affidavit they said that for the last candidate
Assistant
Mohammad
candidate.
Minarul Islam, he secured 59.24. Since the combined merit list has not been produced before the court or my lord to any candidate, I was not in a position to say anything. And my lord, what is my right?
No, did you apply for?
My lord, it was my lord a common examination.
Yes,
It's a common examination. Therefore, my lord, but the
So
thing is how they bifurcated this is unknown to me.
The bifurcation is 5 for them, 20 for them.
Correct.
This was the bifurcation.
As per roster.
As per roster.
100 or 50-point roster, what is
As
And
per
my lord, admittedly, my lord, all the candidates secured, according to page 109, all the candidates secured more marks. If I accept that I secured 43 marks. Therefore, my lord, there is my position is 43. I do not know what marks I have secured. Now, my lord, my right is, my lord, I will say,
But
and my lord,
let us understand.
Yes.
Ms. Bhattacharya, what did you do for 25 vacancies?
My lord.
You
20 for WBCDCL, 5 for TCL.
Right. Now for 25, according to merit, you
Yes, according
panel
to.
the candidates.
Yes.
Now you page 109 shows Minadul got appointment in WBACTCL by securing 59.24 and his rank was 25.
25.
He's the last person.
Last person.
But in the WBACTCL, if it is the common list, rank of Nivedita, how can it be 21?
No, not
Nivedita
common, my lord.
got more
WACTCL panel is separate.
Pardon?
WACTCL is separate, my lord.
So where
They
have
are
you
panel-
stated in your opposition that it is separate?
My lord, kindly see, my lord, the letter, my lord, which was replied by my client, my lord, page 110. This is a reply. Here, my lord, it has been cleared.
Yeah, just about.
110.
Page 110.
110. The letter issued by the West Bengal State Electricity Distribution Company.
Do you have a typed copy? No.
May I please?
This is in connection with, yes, place it with what?
Yes.
Yes, my lord. That in connection with our recruitment notification number PP 2001 dated 1st May 2007, published in leading daily recruitment test was held at Kharagpur IIT, and we received merit list from the authorities of IIT Kharagpur. For the post of AEITC, number of notified vacancies under WBAC DCL were 20, and for WBAC TCL it was 5. Out of the merit list received from IIT,
So there were merit lists, two merit lists.
Two merit lists. Two merit lists. Here merit list.
Received from IIT Kharagpur. No,
Received from
Ms.
Kharagpur.
Bhattacharya, if there were two merit lists, you did not say that you apply either for WBCDL or you apply for WBACTCL. Applicant applied for against 25 vacancy, wherever you get.
Whatever.
So there has to be a panel on what basis you segregated WBACTCL and WBACTCL.
No, that was not there, my lord.
Then how you have done?
We have according to rank, my lord. We have done it according to
If
rank.
it is according to rank, then please come to 109. Rank of Minadul is 25. But rank of Nivedita is 21.
The last appointed general candidates, Mineral Islam, his rank in the said combined list was 25, whereas Ashish Pan's rank was 43, number 1. The last appointed ST in the post of AIT is Srimati Maumita Sarkar, and combined general merit list was 45. Last appointed ST candidate, this is also.
Acha, please 110, please complete. Merit list. 20 candidate, 5 candidate. Some of the appointees did not.
Some of the appointees did not join or resigned after joining.
And thereafter.
To fill up such vacancies out of the notified vacancies as stated above, further sets of panels were made from the said merit list. Actually, 5 sets of panels were prepared after following norms of reservations, and appointment orders were immediately issued in favor of the impaneled candidates to fill up the resultant vacancies due to non-joining or resignation as stated above. The last appointed general candidate in the post of assistant engineer was Muhammad Minarul Islam. His rank in the said combined merit list, my lord, was 25, whereas Ashish Pan's rank was 43.
It was a combined panel. In
Yes,
the combined
yes.
panel on marks basis, they have impaneled.
My lord, that should be, my lord, because page 74, your lordship will find after the written examination, my lord, my name was at serial number 7. And Minarul Islam's name, WBACTCL, my lord, his name was serial number, I do not know, 7, 8, 9, 10, 12.
After completion of the entire process, written and viva voce, Minarul got the higher position than you.
Yes.
True.
Did there any illegality in the selection of the last person?
True. My lord, that is, my lord, I have to accept it from the pleading. I have to accept it. But the
all right, come at 2 p.m. and bring your judgment.
Yes. Now, but before recess, your lordship was, my lord.
Just
Yes. Comment step only.
3 নম্বর কি এখানে দিচ্ছে? 6 নম্বর কি এখানে দিচ্ছে? 5 নম্বর কি এখানে দিচ্ছে? কি অপশন রয়েছে?
কোনো অপশন নেই। কিন্তু দুবার নেই।
Yes, Mr.
Now, my lord, your lordship will, my lord, before recess, considering page 110. My lord, that is a letter written to an advocate on record. This
Yes.
was issued by the additional general manager. My lord, 4th paragraph is relevant. My lord,
4th paragraph.
my lord, this is
Actually, 5 sets.
well, the sentence starts with actually 5 sets. Actually, 5 sets of panels were prepared after following norms of reservations and appointment orders were immediately issued in favor of the impanel candidates to fill up the resultant vacancies due to non-joining or resignation as stated above. The last appointed general candidate in the post of assistant engineer was Mohammad Minarul Islam. His rank in the said combined general merit list was 25, whereas the Ashish Pan's rank was 43. Now, from this paragraph, my lord, your lordship will find that from the Indian Institute of Technology, my lord, they received a combined merit list. Second last line, my lord. They received it, but my lord, for the reasons best known to them, they have not published it.
Wait.
Well, the second last paragraph,
It
second
said
last line.
combined, yes.
Yes. In the said combined merit list, general SC, ST, OBC. So, my lord, in that combined merit list, according to the authority, my rank was 43. I have to accept it, my lord, from the pleading and as per this letter. Now, my lord, the first issue, my lord, so far this documents, my lord, I have nothing to show. My lord, now the pure question of law, my lord, they are the employers. Now, they are the trustees, my lord, to maintain the fairness and transparency, my lord, in connection with a public employment. That's it. That is the facets, my lord, of the natural justice or Article 14, my lord, to publish the merit list, to instill confidence.
No, sir, simply because a combined merit list indicating the numbers awarded to all the candidates have not been published. Does it cast a real shadow of doubt with regard to the genuineness of the successful candidate?
Yes.
How?
My
Why is
lord,
it leading to that effect?
my lord, I have in my ground.
You must show some inconsistencies in this list.
No, my lord, this non-publication itself is bad in law. When, my lord, I have specifically stated in my letter, and after, my lord, that letter, my lord, I filed this writ petition. In one of my grounds was that you have not published the combined merit list. They said that we
is it your case or is it your averment in the writ petition that a successful candidate has superseded you?
No.
My lord, it is not.
There no such.
It is not, my lord. Even as a, my lord, unsuccessful candidate, I have a right to see the combined merit list, my lord. That is the exactly that is the law laid down by the Supreme Court. Because it is all about fairness, nothing else. They are, my lord, Article 12 authority. My lord, they must maintain transparency and fairness in connection with public employment, which they failed to maintain, my lord.
So as that allegation was there that due to this non-publication, you have given persons securing lesser marks
My lord-
might be in the panel.
My lord,
Anyone,
my lord, unless the
you were issued this letter, page 110.
yes, no,
No.
this 110, my lord, was issued by the additional general manager
In reply to your letter.
Yes.
in reply to my letter.
So then you should have said, Mr. Mukherjee, that due to this non-publication, I do not accept your contention that I secured this much of marks.
My lord, it is not that, my lord, I do not know what
Have-
exactly marks I secured unless, my lord, this document,
No, your allegation must be banking on some
my lord, my
rudimentary facts.
only allegation is, my lord, that an employer, my lord, held an
To act fairly,
selection
and he
process.
should have disclosed the combined merit list, from which I could have understood that whether
This is
what
all
they are
about transparency, my lord, nothing else. It's all about transparency. When they says that we have received a combined merit list, my lord, what prevented them not to publish it?
Non-publication of the combined merit list, or rather merit list of all the candidates who appeared in the written test as well as in the interview, precedes the result.
Yes, my lord, that is,
Where is your pleading to that effect?
my lord, I have, my lord, asked for, my lord, if today, my lord, they produce the document, the selection process will not be vitiated. If they fail, my lord, it will be vitiated. In a case, my lord, Supreme Court said this appointment, my lord, from a panel or no panel, my lord, if they, that will be a pick and choose.
There must be some prima facie material to
My lord, the
doubt
conduct
the
itself,
correctness of the panel.
my lord, the conduct of the respondents, my lord, when they in their affidavit, my lord, says that they received a panel, why, my lord, they have not annexed it to substantiate their cases?
Yes.
My lord, my first judgment, my lord, is an age-old judgment, but renowned judgment, Bharat Singh's judgment, your lordship knows, 1988 4 SCC 534. 534, my lord.
Whereas,
My lord, paragraph 13, my lord. As has been already noticed, although the point as to profiteering by the state was pleaded in the writ petitions before the High Court as an abstract point of law, there was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petitions. Before us also, no particulars and no facts have been given in the special writ petitions or in the writ petitions or in any affidavit, but the point has been sought to be substantiated at the time of hearing by referring to certain facts stated in the said application by HSIDC. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point.
Exactly, we are saying so.
this goes against you, Mr. Mukherjee.
Exactly, we
No.
are saying so.
My lord, I have taken that point. One of my ground is, my lord, this non-publication of panel. I have taken that
No,
point.
Mr. Mukherjee, we are wanting to know, have you made any awardment that marks by I have obtained more marks than this?
My lord, how can I, my lord, how can I say?
You could have made an
Because
RTI
they, my lord, my
as that.
case was simple case.
No, they when you wrote that you represented before
Yes.
them. In reply thereto, they said this.
They said this without
challenge that.
Without publishing the panel. So I, my lord, only challenge that action, that non-publication, nothing else.
Show us any provision in the advertisement that it was a obligation on their part to publish the combined merit list.
My lord, if there is no obligation as per their advertisement, my lord, that itself violates Article 16. Even if, my lord, suppose, my lord, if my learned senior friend says that there is no such provision, it itself violates Article 16, my lord. Your lordship kindly consider this judgment, my lord, 1997.
Yes.
5 SCC 298. Paragraph 3 and 4. A few admitted facts are sufficient for disposal of this appeal. Recruitment to the class 3 post in several categories in the state of Bihar was advertised by the Bihar State Service Selection Board. Large number of candidates applied for selection. There were 1,500 posts in all. 5 posts in all, initially 978 and subsequently 127 posts were included for 7 categories of posts. Special educational qualification of graduation and with commerce, science, economics and mathematics, etc. has been prescribed. For 3 categories of posts, only general educational qualification have been prescribed. All are required to have graduation degree as a minimum educational qualification. Before selection of the candidates, the pay structure of some of the posts underwent a drastic change. Some of the posts carrying higher pay scale prior to the advertisement were of a lower grade with lesser scale of pay, while some of the posts due to pay commission recommendations were increased. Be that as it may, when the selection was made and appointments were sought to be made of the selected candidates, as per the affidavit filed in this regard, on a direction given on 30th July 1987, the government claimed that the board considered candidates for various posts as per availability at the time and recommended candidates strictly on the basis of pay scale and academic qualification of job requirements. The High Court proceeded on the premise that no merit list was prepared and the candidates who had aptitude for certain job or entitlement were required to be considered for appointment. Options had not been called for. Therefore, the selection and appointment of candidates without preparing merit list and without calling for the option is arbitrary, violating Article 14 of the Constitution. The question therefore is whether the view taken by the High Court is correct in law. When we ask the learned counsel for the appellant to place before us the merit list to substantiate the stand taken in the affidavit filed in that behalf, the learned counsel was unable to place before us the merit list except the publication in the newspaper that candidates were selected on the basis of the merit. In view of the finding recorded by the High Court that no merit list was prepared and in spite of the opportunity having been given, the government failed to substantiate that the merit list was in fact prepared, we find it difficult to accept the averments made in the affidavit. Under these circumstances, we proceed on the premise that the merit list has not been prepared and the selection came to be made on the basis of educational qualifications required for the job and in some department on the basis of pay scales available at that time. In this scenario, the question arises whether appointment of the candidate is valid in law. When the Service Commission or the board selects the candidates, the normal criteria required is to prepare the list of the candidates selected in the order of their merit and then recommend to the government for appointment to the post advertised for. In that behalf, it is always open to the executive to allot the selected candidates in the particular categories of service in the order of merit prepared and recommended as per the procedure and application of roster and reservation, and on the basis thereof appointments be made to the respective department. Of course, it would be subject to the fulfillment of qualification prescribed for the post, since the government has not satisfied us as to how it was adopted this rationale. The appointment of selected candidates by pick and choose is an arbitrary exercise of power. Under these circumstances, the arbitrariness is writ large. Accordingly, the recommendations in respect of the allotment and appointment of selected candidates is per se illegal.
But here merit list has been prepared.
Well, we do not know. It is only their averment. It is only their averment. Even today, well, let them produce it before your lordship. I will not see to it. Let it be produced before your lordship, for your lordship's satisfaction. Now, my lord, the next judgment is to 2013-11 SCC, page 611. 2013-11 SCC, page 611. Paragraph 10 to 13. Paragraph 10 to 13, man.
Yes, Mr.
My lord, may I place, my lord, paragraph 10? We have, I'm sorry.
Oh.
My lord, this is reported in 2013 11 SCC, page 611, paragraphs 10 to 13. We have heard the learned counsel for the parties at considerable length, even though we have retraced in detail the checkered history of the litigation between the parties. The question that falls for determination actually lies in a narrow compass. The question precisely is whether any panel of candidates has been prepared by the Commission in accordance with the provisions of the West Bengal School Service Commission procedure for selection of persons for appointment to the post of teachers, including headmasters, headmistress, superintendent, such and such, aided schools, and procedure for conduct of business of commission regulations 1918, and if so, whether the same continue to be valid and subsisting to entitle the selected candidates or any one of them to a mandamus directing the competent authority to make an appointment on the basis thereof. We must regretfully say that although repeated rounds of litigation have engaged the attention of the High Court has not adverted to the question whether a panel was indeed prepared and published. It is only in its order dated 27 July 2009, passed in writ petition such and such, that Justice Dotto has noticed the non-preparation and publication of such a panel and clearly held that since the panel has not been published, no recommendation or appointment could be claimed by any one of the candidates competing for the same. We need hardly emphasize that preparation and publication of a panel was the least which any candidate seeking appointment on the basis thereof was required to establish. We repeatedly asked Mr. Mehta, learned senior counsel appearing for Mr. Rai, the contesting respondent, whether any such panel was ever prepared and published as it ought to be, having regard to the very nature of the procedure prescribed under the regulations mentioned above. To the credit of Mr. Mehta, we must say that he fairly considered that no such panel was ever published. Not only that, Mr. Mehta did not dispute the proposition that, in our opinion, rightly so, that publication of such a panel was absolutely essential, not only because the entire process was regulated by the statutory regulations, but also because the publication was essential in the interest of transparency and probity in matters concerning appointment to offices under the state and in matters affecting rights of the citizens in discharge of governmental functions. Therefore, my lord, in this case, my lord, there was a regulation, but here
Where is the regulation? Where is
there
the
was
regulation?
there was a regulation, my lord, at the top of that page. But in this judgment, no, in my, not in my judgment, in the judgment, my lord, my lord, cited, there was a regulation of the School Service Commission. Here, my lord, assuming there is no provision in the advertisement, I do not know because those documents were also not supplied to me. But, my lord, in order to maintain fairness and transparency, my lord, in case of a public employment, my lord, the panel, my lord, ought to be prepared as well as it was required to be published, my lord.
This judgment states about the preparation of the panel
And publication.
Of the list of successful candidates. But you are saying publication of the entire list.
Combined merit list.
Combined merit list.
Yes. My lord, in this case, my lord, this is not about this only select list.
I'm sorry to this. Have you made all the successful candidates as a private respondent in the writ petition?
No, today.
A valuable right has accrued in favor of them.
My lord, today I am not saying, because they said that they have prepared a panel. They are Article 12 authority. And they have not, the IIT, my lord, prepared the panel, it was handed over. Now on oath, they have said this before a court of law. Now, that panel has not been produced. Now, my lord, I put this question to myself, is it not a duty of an Article 12 authority in order to maintain transparency and fairness that this is the panel, we forgot to publish it, but this panel we received and therefore your rank is 43.
What is
Matter
page,
ends.
What is page 95, Mr. Mukherjee?
Matter. My lord, this was a shortlisted candidates for interview.
All right.
So even here, it has not been, entire list has been published. Only a short list has been published.
Even my lord,
qualified for interview.
my lord, there is only one thing.
Did not challenge this because you have succeeded there.
My lord, whatever they have, my lord, produced before this court, my lord, these are the, my lord, chart or list prepared by them, not the committee, my lord, the committee, my lord, for the selection process, my lord.
Anything else, Mr. Mukherjee?
So, my lord, that's.
Yes.
My lord, on this matter, my lord, in the page 133, my lord, I am submitting that, my lord, that he is in the merit list, my lord, at the bottom.
Page 133.
133. My lord, this is the ordering portion, my lord, page 133.
Yes.
Here, my lord, I have rely on two judgments, my lord. Second para, the learned advisor, that is, my lord, Dhananjay Malik and others
No, that you
versus.
leave out. What is his prime contention is that you did not produce the combined merit.
My lord, combined merit list, my lord, he is asking for entire merit list, my lord. But which is, they say there is no such provision. And this is, and we are not also, my lord, obliged to publish the entire. This is not a 10 or 15 months, my lord. Huge public, my lord, appear in the examination. So in any case, my lord, other case also, my lord, nobody published the entire unsuccessful candidates. It is not possible, my lord. We have time to time, my lord, we have advertised, my lord, the successful candidates 2 or 3 times, my lord, because some doesn't join, my lord. Some, my lord, that's why, my lord, we have done it, my lord. But entire is, my lord, there is no such provision, my lord. That unsuccessful candidates, my lord, no department also, my lord.
So the thing is that you published 5 lists. 5 lists you published.
Yes.
So this process went on for a subsistent period of time, no? When you have shortlisted them on the basis of written test, thereafter you publish the interview list. His name featured. Now after interview,
because some
there was a
person resignation given, my lord, some person did not join. We have to wait for that, for their join, my lord. Secondly, my lord, unsuccessful candidates cannot, my lord, challenge the selection process. Secondly, my lord, there is no allegation that any person, my lord, they say this certainly, just 1 minute, my lord. He has not challenged, my lord, any particular candidate who had been favored with appointment. That is not also there. He has not denied that his rank is 43. He knows very well. There is nothing to show. We have stated my affidavit. We have given our reply. That has not been challenged by the petitioner.
No, that he has given in his affidavit in reply at page 118.
But in the read
that
petition,
marks of 2 petitions are not tallying.
But
kindly come to page 118.
In the read petition, my lord, there is 118.
This is in reply to your paragraph 4 of your opposition. Their reply. They said that I state deponent has not disclosed that combined merit list with names and number. At any time not disclosed the name and category you have joined and resigned. On such times it is not at all believable. Even adopting the last appointment SC and ST candidates, Moumita and Amit, whose rank were 45 and 52 in the combined merit list. As such, the entire statement is bad. Now, this is a selection of 2007. In the REIT code, did the REIT code ask for the combined panel at any juncture?
Although, my lord, before the learned single judge, my lord, I was not there, so I should not say.
Ashok, the present appeal has been preferred.
It's a pleasure. Great moment.
Item number 18. Paper book আছে হলো
আছে book আছে
Any paper book used, Mr. Neil?
paper has been filed. No,
Will
my
it
lord,
be possible
paper
for
book
us
has
to
not been
finish
filed,
it
my
off?
lord. Has not been filed.
Pardon?
Ready, paper book is ready, my lord. I'll file it by tomorrow.
Is it a short matter? Will it be possible for us to dispose it off? Because my brother won't be there next week.
I'm sorry, my lord.
But what termination?
My lord, this is regarding appointment to the post of development officer in the Tea Development Corporation. Denial of appointment.
In a selection process?
In a selection process. And the selection process tainted with mail of ID. My lord, interview was held. After the interview, my lord, the qualifying mark was my lord, increase or decrease. No result was published. After I came to this honorable court, then result was communicated. These are the all our points are there. My lord, by tomorrow, I'll file paperwork. Next Monday, I will take it.
Monday it cannot be fixed, Mr. Neil. Then it will go in the monthly list of January. It will retain its place.
May I file the opposition matter to this? There was a direction.
To the the section stay application.
Stay application.
Mr. Nyogi, you have used any reply?
Stay application.
Was there any direction?
Opposition and reply has been included in the paper book.
Opposition and reply of the writ petition has been annexed in the writ petition.
Not
No, a stay application opposition was called for. Heard Mr. Nyogi, learned advocate, appearing for the appellant. Mr. Chatterjee, learned advocate, appearing for the respondents, files the affidavit in opposition, comma, as called for earlier.
All are included in the paper book, my lord.
Original দিয়ে দিলাম
My lord.
No, this stay application is affidavit is not there.
In the paper book.
Paper book incorporates the stay application affidavit. Did you give the copy to him earlier?
Yes, yes.
Copy has been served. He has
Yes,
used
I have annexed in the paper book, my lord.
Oh, you have annexed. You have filed a reply.
Yes, my lord. Everything is ready. Everything is ready, my lord.
Oh, তাহলে এখন কেন ফাইল দিচ্ছ? You must have filed it earlier.
But the matter was not taken up thereafter, my lord. And it was not hard. That is why.
Did they use a reply to the same?
Everything is there in the paper book. My lord. The original
এখানে
was
আছে
with.
নাকি paper bookটা?
No, it has not been filed as yet.
Oh, you have not yet.
Reply you have filed?
Yes, yes. Everything included in the paper book, my lord.
No, that I have understood. Whether affidavit reply as against the affidavit opposition has been filed or not.
Original reply টা জমা দিয়েছেন সেটা?
This is the first time, my lord, this has been included.
Let the affidavits affirmed by the Mr. Chatterjee, learned advocate, appearing for the respondent number 1, files the affidavit in opposition. Let the same be kept on record. Mr. Nyogi, learned advocate, appearing for the appellant, submits that pursuant to an earlier order, paper books have already been prepared, incorporating the pleadings exchanged by the parties before the writ court, as well as the has already been prepared. You have filed the paper? No.
No, my lord. I will file it by this week, my lord. Paperwork is ready, my lord. Ready paperwork.
ও তাহলে লেখো মিস্টার নিয়োগী লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দি অ্যাপেলেন্ট সাবমিটস
My lord, item number 19, I am for the appellant led by Mr. Robilal Moitro. My lord, Mr. Moitro is not feeling well today.
How is he? He's coming to court?
He has rejoined. He is coming regularly. Today, I think he has lost his voice, literally. He is unable to speak properly today. That's why he's just praying for a day's accommodation. Tomorrow, he said that tomorrow he intends to do this matter tomorrow.
Mr. Dev, this will go to the next monthly list.
My lord, let it remain in the list. We are otherwise ready.
It will remain in the list. We shall take it up on January.
My lord, if it goes in the next monthly list, then it
You will be in problem. If we pick it up and place it somewhere else, your file may get, your file in the interregnum may be
My lord,
disturbed.
tomorrow, my lord,
My, what is the matter about?
my lord, grant file to them.
19. Monowara Maji. You are opposing.
Granting certain benefits to the appellants who have been working as daily waged laborers for a prolonged period of more than 20 years. This is the issue. I am squarely on a notification of 2010, which was reiterated again in the year 2011. The Sundarban Development Board came to a resolution that they have been continuously working for a prolonged period, and as such, they are entitled to certain benefits. Now, my lord, certain questions, certain queries, better to say, were raised by the coordinate bench, wherein affidavits were called for from the state with regard to three specific points, that whether in terms of our submission, whether we satisfy these three specific points or not. State has also come up with a report, and we have filed a counter to the report. That I am filing.
That you have not annexed in your paper book?
No, my lord. That was done pursuant to the order passed by the coordinate bench on the last occasion. These documents, some of the documents already form part of the paper book.
No. Where is that order? Let this appeal together with application appear. With appeal bearing and the application being number ato.
That was the first order passed by Justice Dipankar Dotto, as his lordship did. The last order by Justice Boshak, my lord.
It does not.
Lordship kindly sees the last order passed by Justice Boshak.
নাকি ওটা দাও, এটা কোনটা?
ওইটাই বলছি। এইটার আগের অর্ডারটা।
Now then, both the appeals have been preferred by you.
Both the appeals preferred by me. One of the appeal, there were two writ applications. The first writ application before Justice Sanjeev Banerjee, that was dismissed on merit. An appeal was preferred. Before the appeal was preferred, a subsequent writ application was preferred before Justice Banerjee. That was dismissed on the point of res judicata. Another appeal was filed. Now, the appeals were clubbed together and were placed before the bench of Justice Dotto. Justice Dotto observed that we will only hear, the paper books would be made with regard to the appeal coming out of the first writ application, and on the point of limitation, we are not taking into account the appeal which cropped out of the dismissal of the second writ application. That is on record. Now the final hearing is taking place with regard to the appeal which was preferred, challenging the order of dismissal in the first writ.
All right, we shall hear it.
My lord.
Let it retain its position in the list. We shall take it. Most probably it will be reached after the regular bench sits. You try your luck.
My lord, lordship says this is the regular bench, my lord. Oh.
19th, we will after not this week করে রাখুন কার্তিক, তাহলে ওই যখন ডাকবে ওই আরেকটা ম্যাটার ছিল না?
My lord, can the matter be not placed in the supplementary list? Mr. Moitro was my learned seniors. This is the only request that since this matter has been prolonged for so long time, and my lord,
We'll take it up whenever we will. From tomorrow again supplementary list will be there. After conclusion of supplementary list, we will again take up the combined list.
my lord, let the matter retain its position on the top of the monthly list at least. Otherwise, my lord, it will not be called. That is the only difficulty.
We have called these matters not less than 4 times last month.
My lord, this matter for the it has
This appeared earlier also. This was
when
in the
lordship was sitting previously.
No.
It's just within this.
During the last week, sir.
Last week, my lord.
This court number 11.
With Justice Chatterjee also, we called on the entire list.
My lord, I am filing the my affidavit on behalf of the appellants in connection with the report filed by the respondents.
That has you have enclosed in the paper book also.
No. This is pursuant to the direction of Justice Boshak.
Where is the direction to file a report?
My lord, that I'm.
See that order of Justice Boshak. Where do
Well,
you
that's
find?
I'm trying to find the order sheet. Then the order sheet গেল কোথায়? My lord, kindly grants me 1 minute time.
Keep it with you. We will take it up on the next date. ওটাকে not this week করে রাখো. Next day যখন
তোমাদের
ডাকবে
কপি দেওয়া
তখন-
আছে।
Yes,
আমার
next.
ট্রাক দিয়ে দিয়েছে সব কই। এই লাস্ট অর্ডারটা কিন্তু আমি দেখছি না, জাস্ট আমি সার্ভার কপি আছে আমার কাছে। সার্ভার কপি আছে না? প্রিন্ট করে রাখেন দেখেছিস?
It is made not this week, but your matter will be called on. Again, when we call the combined list, it will go to the top. Most of the
Well,
matters have been.
well.
Yes, next.
Item number 21.
21. Achin Mujib, where is he?
Sir,
Mr. Mishra,
my lord, he is engaged to courtroom 23.
You are ready?
so my lord, Mr. Mishra is there for the
Praying not
respondent.
this week, my lord.
Then it will come in the next month list. Next. Yes.
My lord, I am for appellant. Praying not this week.
21, 22. Not this week. It is made not today. When we come back, we will again take. Yes.
কোনটা হয়নি? পুরা হয়নি।
You are appearing for whom? State. There were private respondents.
Yes, 2 private respondents initially.
Have you served the paper book upon them?
Yes. It was served. Subsequently, they didn't appear. The state was directed through the district magistrate to intimate. That was also done according to my learned friend. Last day, your lordship passed an order.
You have, where is your affidavit of service?
Affidavit of service টা কোথায়?
We passed an order on 18th November.
Yes.
Asking you to serve upon
Yes.
8 and 9.
That is there. My lord, one has been served. My lord, she has received. Another, my lord, I don't find that she has been served. My lord, this is the affidavit of service.
So what we are to do, tell us, Mr. Islam.
My lord,
It is upon 9 and 10.
9 and 10.
No, it is, you're saying only upon one.
9 and 10.
Yes.
On 9 accepted the service, 10 possibly not accepted. Track report
You
shows.
sent to 10.
Yes, yes. Nine delivery confirmed, but 10 it yet to be made.
It has been dispatched, not yet
10,
received.
10 not confirmed, 9 confirmed.
What is the matter about?
My lord, matter relates to selection of Asha.
Oh, achha.
That matter, learned trial judge observed that I was, my lord, removed from the zone of consideration, though I was of the resident of the same village. I should have been given the appointment in place of me, subsequent advertisement done, and somebody has been given appointment. That is respondent number 10. Since somebody
Do one thing, you
Sir, how you are prejudiced? Because the learned single judge has directed for causing an inquiry. So,
my lord, before that, causing an inquiry,
if the outcome of the inquiry is not in your favor, you have
no,
taken right to approach the appropriate forum.
no inquiry with regard to the officials who has erred in the selection process. But insofar my appointment is concerned, well, that has been declined. Your lordship kindly sees page on 53, second paragraph, judgment.
internal page?
Well,
5.
5.
Yes, read in the aforesaid facts and circumstances.
Yes. There is no vacancy in respect of Bhagavanpur sub-center due to the as the present. It will be harsh as the stage if the appointment of Suraya Khatun is set aside, holding that the entire selection process under 2020 notification was vitiated. At the same time, it will be unfair to Nargis Khatun, this appellant, being the petitioner in such and such, if due to arbitrary step taken by the state, a selected candidate who is otherwise eligible for appointment is deprived of the same. No relief, however, can be given to Nargis Khatun in view of the present situation. Well, I have been declined the relief. Though it was heard that I am the most suitable person, I should have been given appointment. Since somebody has been appointed after my lord, fresh selection process,
Suraya Khatun service not effective.
yes, she has not received.
He is the answering respondent, no?
My lord. My lord, DM also intimated the earlier order to Suraya Khatun. আপনার কাছে রিপোর্টটা আছে? Your lordship, last direction was, since there are 3 attempts to Suraya Khatun to notify the appeal. My lord, delivery confirmed. Affidavit of service was submitted. In spite of that, she didn't turn up. Last occasion, Justice Boshak directed the state to communicate the order through district magistrate. That has also been done. In spite of that, she is not turning up.
Where is the report? Where is the report of the district magistrate that the service has been affected?
Earlier report is in the paper book.
না না district magistrate বলেছে
No, there was a direction upon respondent number 5 to intimate 9 and 10 because they are presently working. Your file.
ডিএম এর রিপোর্টটা দিয়েছিলেন
Documents. That was we are making it not today. You effect not this week.
Not this week.
You ensure service has been affected and come back to us so that we can hear. It take to another ফেরত
সার্ভিসটা হয়েছে কিনা দেখে নিবে অবশ্যই দিয়ে আবার রিঅ্যাফার্ম করবে ঠিক আছে
Yes, reaffirm.
লর্ডশিপ
আরেকটা করে দেবে, এটা তো ইনকাম ডিসপ্যাচটা পেয়ে গেলে ওটা করে দেবে। ইয়েস, নেক্সট।
Deep.
24, my lord, I beg to appear on behalf of the writ petitioner appellant. My lord, I am led by Mr. Partho Sarothi Bhattacharya. My lord, the appellant before your lordship, he is a superannuated employee of my lord Calcutta State Transport Corporation. He is, my lord, seeking to avail pensionable service. Now I must be candid to your lordship, my lord, the principal dispute is whether any option form was at all submitted by the writ petitioner or not. I say that I had exercised option. The stand of the CSTC is that no option form was submitted. Now there is another aspect of it, my lord. There is a resolution of my lord CSTC, my lord, which was held of a meeting held in presence of the chairman CSTC, wherein they have acknowledged and admitted that large number of option forms were, my lord, lost and misplaced. Now, my lord, in order to resolve this dispute, the earlier coordinate bench of your lordship, presided over by my lord Justice Bosak, their lordships were pleased to, my lord, grant us liberty to take inspection of a register, which has also been referred to in the resolution. Now, my lord, I went there personally, my lord, along with the appellant, and they have communicated me, my lord, handed over me a communication, my lord, with a shocking revelation, my lord. May I only hand over this, my lord? My lord, that no such register is traceable. So, my lord, this solitary evidence through which not only, my lord, the appellant before your lordship, my lord, but hundreds of employees, my lord, could have substantiated their claim apropos, my lord, submission of option, my lord, that is no longer available. My lord, may I hand over the communication, my lord?
When did you retire?
My lord,
Got
I
the-
had retired, my lord, on 30th of June 2006.
Did you get GPF? Contributory Provident Fund you got?
My lord, I received the amount of gratuity, my lord.
And not pension?
Not pension.
কাট অফ ডেট করেছিল, এবার দেখা যায় কাট অফ ডেটে যদি এখন এটা সেটা প্রচুর। আচ্ছা আচ্ছা, হ্যাঁ আপনি কথা বলতে
The register which you are referring now, that has been referred to in the affidavit in opposition.
In
Before
the,
the
no, my
report.
lord, the surprising part is, my lord, that the factum of loss or misplacement of register, my lord, and the option forms, rather the option forms, my lord, it was never intimated to disclose to any of the employees. Otherwise, they could have, my lord, once again exercised their option. Since 1991, my lord, they have suppressed this information. And the register, my lord, is the only
Mr.
document.
Sen, why it is not being given in all the departments now?
My lord, the total fact was different. My lord, it's a, my lord, they are trying to twist the fact in other way. If your lordship kindly go through the order passed by the learned single judge, whereby the writ petition was dismissed on merit. Now, my lord, a new document they placed in, my lord, state petition being the CAN 1. A new document that is, my lord, one, my lord, alleged, my lord, the discussion with the managing director and the chairman of the then at page 146. It's a new document. Now, if your lordship allow me, then I can tell, my lord, the actual facts, my lord, not, my lord, I cannot take much time.
No, pursuant to
Yes.
the earlier order, you granted them inspection. pursuant to the order of 20th September,
Yes,
inspection was granted.
my lord, may I
So
tell?
very good.
Yes, yes, yes.
After inspection was
After
granted, you were
inspection-
communicated this order.
Yes, after,
On the day of the inspection.
my lord,
So
this is
please
a-
let him bring that on record. Let him bring that communication on.
let him bring that on record, or we can also, as an authority, yes, this is also a part of the communication scene. But my lord, may I tell one thing, lordship? Well, this is an individual application, not on behalf of the any other employees. An employee who, after retirement, after obtaining, my lord, the gratuity, then, my lord, after so many years, he said that I have opted pension. Because may I tell one thing, lordship, in, my lord, 1990, my lord, the regulation came into effect with regard to a clause.
We are not on merit, Mr. Sen.
No, I am
We
not
are-
also not.
We are wanting and what do you want to file?
With regard to that at the time of inspection, it appears, I think, my lord, if your lordship, he can also, but I can also file this, that on the basis of the order of this court,
Yes.
where it appears that without prejudice to the rights and contentions of the respondents, the appellant never filed under the CSTC Employees Death Cum Retirement Benefit Regulations 1990, as indicated at page 146 of Can 1 of 2024.
No, that
It
is
would
your
be-
instruction. That is your instruction.
my instruction and the affidavit filed before the single bench also, that
Those are already on record. Paper
everything
books you
on
have
record,
filed.
everything on record,
Filing of paper book was dispensed with, my lord, the formality.
everything on record.
And the last document is not on record.
Bearing this document, which is the further development passed by this court, directing that there is one line in the, my lord, discussion, that apart from personal file, where the option form should have been kept, apart from personal file, there is a register, there may be register.
No.
To
There is a
তাহলে
register.
আপনি বলুন, আমি চুপ করে থাকি। It appears from that particular proceeding, where it is annexed at page 146, that apart from personal file, PL file, there may be a register to record this. When the personal file, it does not appear that there is option form, it may be found at the register. So this is the recording in that, my lord, at page 146, the new document, that is the, my lord, the discussion held. Now,
very
going
good.
through the same, the court said, very good, ask them an opportunity to inspect the register. Now, my lord, it appears from the, my lord, when we wrote to the particular department where he served at the time of his, my lord, retirement, the particular department, the depot and the head office said that there is no such register. But he was asked to, my lord, inspect the personal file, but he refused to inspect the personal file. Because according to us, in the affidavit, we have stated that in personal file, there is no such option with under this scheme, DCRB scheme. Rather, it appears from our affidavit and in the personal file that this very gentleman opted for EPS 95 scheme. EPS 95 scheme he opted for. There are letter and annexure in our affidavit, in his writ petition also, that I did not opt under DCRB 90.
Mr. Sen, what you are wanting to bring on record?
I want to bring on record also that this is our internal document, that we wanted, we sought for that particular register if it is available or not. And
Then do one thing, let him, we will say
no,
pursuant to
this
the-
is this you what you want to submit is the communication to you, to the, my lord, the petitioner or petitioner's advocate, that the register is not available. What I want to submit by your affidavit, that this communication to the
No, Mr.
petitioner's
Sen,
advocate,
we will ask him to bring that on record. We will give you liberty to use an opposition exception to the same if you desire. In your exception, you will incorporate.
because I want to place that there are basis of that communication also. There are two other documents.
Mr. Ganguly, learned advocate appearing for the appellant, prays for leave
could not follow.
Junior sought to bring it on
My
record.
learned friend could not follow.
He says that I want to bring on record. a
Then I
copy
told
of
him
the-
to Miller continue the proceeding. I asked him.
No, we are not saying that because the
I have
paper
no
books are
problem.
ready. Paper books were dispensed with.
I
Now,
have
in
no
view
problem.
of the earlier order, a different.
He wanted to bring on record a particular communication which was made to him.
And
This
I
is the
want to
thing
bring,
he
yes.
wanted to rely on.
So what
Then
is
I'm
the
just-
difference? If I place this by way of affidavit along with the documents that also, my lord, that based on this, on the basis, what is the basis of this document that that we sought for from the other department, and the department said there is no register, and then this communication. They want to disclose only one communication. I want to disclose another paper connected to this.
Both these documents are pursuant to
The order of this court. Yes. Because may I tell one thing? Then the same document,
ফ্যামিলি ক্যান্সার স্কিমে যে আসতে চাইছে সেখানেও কোনো কন্ট্রিবিউশন করে পুরো টাকাটাই ওর অ্যামাউন্টটা পুরো টাকাটাই চলে গেছে এতে মানে গ্র্যাচুইটিতে চলে গেছে।
পুরো টাকা ফেরত দিয়ে দেবে। যেটা যেটা থেকে কাটলো নয়, যদি দুটো ইয়ে আছে, একটা হচ্ছে গ্র্যাচুইটি আর একটা হচ্ছে জিপিএফ কাম ফ্যামিলি পেনশন।
To copy
যদি ও যদি কন্ট্রিবিউটেড ফান্ডেড
আমি একটা আমি তো
yes, my lord, may I tell? My lord,
In the personal
service book,
there is no reflection
there
that
is-
he has
yes, and my lord, they refused to, my lord, the inspect the same. They said no, only that register what is mentioned in that resolution and not discussion. Now, my lord, after this order, if you also kindly have a look this letter. After this order, my lord, we wrote to the department, the specific department where he did serve. Now that if there is any such register, then please place the same for the purpose of the inspection in terms of the order. And in reply to that, department said to the, my lord, the concerned office that no, there is no such register, and only that portion had been communicated to them. So I want to place this both the letters, that after the order where we sought for the register and the answer to department.
Why did you give them that letter?
Because the after inspection, there this letter at the table in inspection table.
These becomes all subsequent documents. Why should we allow you to bring in further documents?
For that document, because there was an order to give inspection.
Right.
And at the time of inspection, it appears from our record that there is no such register. It was intimated to them in this way. That's see.
And at the same time, it has been intimated that individual such and such form was kept in the personal file of such.
Normally, yes. And he was asked to inspect the same, but he refused because he said that this was not the order. Order was to inspect the register, but not the personal file.
GDBT দিয়ে অন্য গল্প পাঠিয়েছে হ্যাঁ সাবসিকুয়েন্ট ডকুমেন্ট তৈরি হয়ে গেছে
এখন তুমি দিতে সবকটা
Petition itself, and even in the state petition, that the petitioner always during the, my lord, the tenure of his
So the
service
question which is
opted
haunting
for
us,
EPS
that
95 scheme
question which is
pension.
haunting us, that while disposing an appeal, we'll start considering the fresh evidence or not. That is the difficult.
Yes. And the order was passed, my lord, without prejudice to my contention when the order was passed on the last.
Very good, very good. Okay, কোন চিঠিটা যে?
ওইটার পর
এটা?
না এটা তো ডিপার্টমেন্টাল লেটার।
Where is your letter? দেখি দাও।
এই দুটো কপি দিন।
Documents set.
এই চিঠিটা না না এইটা তো ওদের কপিটা দেওয়া হয়েছিল, সই করিয়ে দিয়েছে, কপিটা দিয়ে সই লেখা।
So it is an interdepartmental letter.
Interdepartmental.
Copy of which is being forwarded
It
to you.
was handed over to me during the course of inspection.
Result তো সেটাই একই।
Same letter. Same.
বাট এইটাকে জাস্টিফাই করার জন্য ও রিপ্লাই দেবে, বুঝছো তো? আবার ইমিডিয়েটলি এটা যে অ্যাকসেপ্ট করবে। Now, did you only communicated this letter, not the other letters annexed to the file?
No, it has not. No, it was not.
Let us do one thing, Mr. Sen. We shall give him leave to file a supplementary affidavit to bring on record this document which was communicated at the time of inspection pursuant to the order of the. Let him bring that on record. So far as your documents are concerned, while hearing his plea, if we find that you have justifiable reasons towards such contention as reflected, if required, we will call for.
Mine.
Otherwise, it so happens that again it becomes an additional evidence on their part.
Yes,
and
yes. I leave it to
you
you.
give a copy to Mr. Sen by filing an affidavit in the
Yes.
supplementary affidavit.
Copy of the affidavit, my lord. I shall definitely hand it.
Ashu Mr. Bhattacharya, learned senior advocate, appearing senior advocate, assisted by Mr. Ganguly.
Get.
Number 25, Your Lordship, I am for the respondent. I'm led by Mr. Kushal Chatterjee. I'm praying for a day's adjournment, Your Lordship.
This matter is arises out of the The improved order was passed by Honorable Justice Sen.
By my brother. As the order impugned in the present appeal has been passed by one of us, comma, bracket সাহেবের নামটা লিখে, comma, the matter stands released from our list.
Released or the regular bench, my lord? Chatterjee is coming.
Now you have to go for assignment. Let the matter.
টেম্পোরারি আছে রেগুলার বেঞ্চে দিয়ে দেবো
Oh, acha, acha.
It is adjourned, my lord.
Oh,
হ্যাঁ
then adjourn for next month.
নেক্সট উইক করে দিবো
Next month, sir. Next month,
Next month.
January,
January.
my lord.
Oh, sorry. But these are every service. হয় লাগে তাহলে আপনাদের যখন দেখবেন
But last time was nobody appeared on behalf of the respondent.
how can they appear? Are they not
I have
afraid
some
of
note-
Bhattacharya? Everybody is afraid.
No, no, no. Dredging Corporation, my lord, who appeared before the trial court.
Yeah.
I told him, but he initially yes.
Oh no,
he
he
served me a
will not-
copy. But now, after your lawsuit order, he told me, no, 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 you serve notice upon all the respondent. I shall not appear. Karidar Saha.
He saw you are appearing finished. ছেড়ে চুলে চলে যায়। বল।
But the application,
give us 2 minutes time.
maybe I did, but improved order. Oh, yeah.
ওয়েট ফর সেক
Yes, yes. এটা দেখি তো বলছে দেখি। Thank you very much. What are the costs? 16, no? Yes. TV बुझा दो, ये भी जीरो। Just correct.
আপনারা তো কোয়ালিফাইং পিরিয়ড অফ সার্ভিসেস
deficiency problem. সরকারের deficiency, মৌসুমি deficiency হবে। এখানে অনেক দেখবেন 91 জয়েন করেছে 2000 সালে মারা গেছে মার্চে। তার মানে 9 বছর 9 বছরের থেকে একটু কম কাজ করেছে।
মার্চ 29 এটা হয়ে গেল মার্চ 21 থেকে
না মারা গেছেন
না সরি মার্চ জয়েন করেছে কবে
10th June 91 first stage, fourth line 91 জয়েন করে 2000 মারা 10 বছর কমপ্লিট হয়ে আসবে। আচ্ছা, তারপর এপ্রিলে একটা চিঠি by the it was into April. Okay. 21শে মার্চ ওকে আনফিট বলে বের করে দিয়েছে। কি
On the ground of delay. But delay is not a ground.
সে নয় বুঝলাম, কিন্তু
Delay is not a ground. Your losses know that
your entitlement to pension was not there, Mr. Bhattacharya.
no, I am entitled. Prior to that, but on
You entered into service on 10 June 91.
yes,
You died in March 2000.
29th March 20.
So you rendered 9 years, some months of service. 9 years. So there was a shortage. Very good. Now after that, prior to your
Appointment of 1991.
91 থেকে 9 বছর it takes the
8 years, 9 months, 11 days. You have served.
I have served.
Then
I am
you
entitled.
died. Then you died.
Qualifying service period is 10
But if I qualified, if it's a death, my lord, I am entitled. But that probably
No. Why it has been dismissed? Trial judge said that you entered in the month of 91 June. You died on March 2000.
March 2000.
Prior to that, they issued a letter on 15th.
No, 21st March.
Was issued and
I have been, they informed after they informed that I have been the husband, the petitioner has been discharged from service. Initially, I sent a telegram. They accepted it. On receive the telegram, that he is dead. Thereafter, they sent a letter.
Listen to us. You have been appointed on 10 June 1991.
91.
You have been declared unfit and your name has been struck out from the
When?
roll.
After death.
21st March 2000.
After death. That was communicated after death. The moment he
21st March, you died on 29th March.
29th March 2000
was communicated later. Unfit হয়েছে prior to death.
But is it possible, my lord? You also kindly see page. Kindly 24. There is a condolence. There.
রাগারাগি করলে মামলা।
No, at that point of time, that was not. It is afterthought. Afterthought. Since he is died,
No. We had lowered your voice.
Oh, yes.
condolence এটা পাঠাতে page
Oh. But page 24, they sent a condolence. 24.
Page
24. The moment on 31st March. Have you got it, brother?
It's 24.
24. Condolence. Referred your telegram dated 31st March 2000. Informing that Sri Anil Chandra Das expired on 20th March. That's letter dated 12th April 2000. 12th April. Top. Date 12th April 2000.
Subsequent to death.
They came to he is dead, then page 28.
What is the content of the telegram?
Which letter, my lord?
Page number 24.
24, yes.
What is the content of the telegram?
Referred your telegram 31st March informing that Sri Anil Chandra thus expired on 29 March, we deeply express our hearty condolence for the sad demise of your husband, such and such.
So it is an answer to your telegram.
Yes, answer to my telegram.
Huh.
Then page 28. No intimation that he was discharged from service. When this order was issued, what if the person is dead? Since Anil Chandra office order, such and such dated to 15th April. Anil Chandra monthly pay such and such was declared permanently unfit for his such and such with effect from 21st March 2000. Accordingly, such and such is deemed to have been discharged from service. Thereafter, after this, yes, that is a delay also, I know. If sent a letter, the petitioner giving, yes, yes. Yes. First, if sent an application to authority to give a appointment on compulsory appointment. A refuse that was not yes, turned up, but no, not given to. Then just a minute.
When was the compassionate appointment prayer rejected?
Within 6 months.
Yes. So what is it? Show us.
April 2000.
There's 39. Yes.
Acha, come to page 30. You are sure? Rejected.
It is spelled out in the order also. Impugn order. Impugn order. Everything has been
Rejected what? You applied compassionate appointment?
compulsory. No answer.
Not accepted.
Not accepted. No answer. There was your sitting tight over the matter. Yes, yes. After Noniwala, when the Noniwala came to us,
Page 30. Penultimate paragraph.
30. That paper book page 29, my letter.
Next page you turn. Penultimate. As per office number such and such of 1992, employees of corporation who have rendered more than 5 years will come under
Employees pension scheme.
that circular.
Come, yes, yes. Is it come under the provisions of Provident Fund?
আমি জানি না।
Yes, yes. Yes. Chalo. তুমি separate করো। First, your logic can you see? Just a minute. $27. Page 27. Office order.
Is declaration of provision of MPW.
Yes. Then you also can see declaration provision such and such. 2. On regulation MPS, they are entitled for wages, another allows overtime, bonus, seniority, such and such, supplement, unit, such and yes. Then H, clause H. Above observation subject to production following document H. Employees for
5 years service.
5 years. Yes. That is the here. I just put good. Employees Foreign Fund Scheme. Employees Foreign Fund Scheme.
Employees pension scheme.
Yes. First one out the page 170, 82. They start from 82. Then your, my lord, page
And it shows that provision that you become entitled to family pension after 5 years of service. Where is that provision?
well, that is come under the employee punishment scheme. Well, kindly see para page 91.
Yes.
Proviso, para 12, proviso,
Page 91.
91. Proviso. Provided that on from such and such, minimum pension 1,000 such and such. Then, my lord, B, 3.
So what is it? Very difficult to not be very after 20
Provided provided if the member does not take up an employment probable under this scheme and has rendered less than 10 years eligible service on the date of exit, but dies before attaining age of 58 years and before a continuous period of 36 months had elapsed, during which contribution have not been received in respect of member in the pensions fund, the amount of contributions received in his case shall be converted to a monthly widow pension or children pension, and the widow pension in such case shall be calculated at the scale laid down in table C, and the children pension 25% such and such. The second proviso also that if the member does not,
suppose I am an employee.
yes,
You have terminated my service or you have discharged me from service.
yes,
Or challenge that order, then I am not at all your employee now.
on a wheel challenge, he is the person dead. After his,
That's why your wife ought to have done something. It does not do anything for 20 years. How can you come across this hurdle? Order of discharge is not under challenge. If your relationship with the employer has ceased
yes,
on the basis of an order of discharge on the ground of unfit category, your entitlement to pension does not survive.
now I have understood, my lord. Person concerned died prior to that, prior to issuance.
Communication was after death. Discharge was prior to death.
It is a afterthought that the moment came to know, sent a, but I am saying it. But by sending the telegram communication to them, they did not say that on that day, 12th February, that your person has already, that Anil Chandra has already been discharged from service. দেখেছি জেনেছি ইয়ে করেছিল ওরা দেখেছি যে দেখে তো কথাটা বলছি Then page 36, your losses, no? Your losses. Page 36. Page 34. On this is the demand notice, they gave a reply. Page 34. Yes. The lawyer on 25th April 2022. Repent, received. The matter has been examined. In this regard, it is observed that the case in respect of Sri Noniwala Das, wife of late Anil Chandra Das, so referred, is more than 2 decades old, and there is no details or information supporting documents, etc. Every designation, code number, joining order, relieving order, etc. It is therefore requested to forward all the supporting document, information, etc. in support of your claim, enable us to examine the case further. Then I gave a reply. Page 36.
Page
36. They're ready to give. They did not say, no, no, he has already been discharged. He said, after 22 years, you are sending, your client is making claim. Send a letter with reference to your above data reply sent to me on the basis of my legal notice on behalf of my client, Dhoni Baladas. I am sending or submitting the following documents of Beijing Corporation of India of the year 2091, whereat allotted code number, date of joining, designation, this is Anil Chandra Das, petition of my client, are mentioned. Thereafter, they did not take essay. I did not get any reply. Then I filed a writ application. And writ application I made only on the ground of delay. It is not against that the threshold they rejected the prayer. And gratuity provident fund, paid.
My client died in harness.
একশো একানব্বইটা বার কর পেজটা 10 years আগে হয়ে পাবে বার করলো কালীপদ সাহা
লিখেছি পেপার
কালীপদ সাহা Yes, yes, yes.
I know him.
When a para 12 says if provide less than 10 years, he will get. My client is now, is it Kalipad Saha? No, Trivedi. Today, Deputy Additional Solicitor General is here. Kali, it's a matter another day after tomorrow, I shall inform. I shall inform. And otherwise, Mr. Ashok Chakraborty, I shall inform Mr. Chakraborty. He sits in our table also.
Get hold of him and come.
Yeah, he will come.
Get hold of him and come.
Yes, today.
Ah.
Today. Yes, going there. I do not know whether he is now, he will be available or not. Now, 4:10.
Cannot give, Mr.
What is para 20 employee permanent scheme says their stand was super, EB below 10 years eligible service. But 16 parasite, I have shown to your lordship, provided below 10 years, he or she is entitled to get. Widow is entitled to widow pension, there is scheme. And he died.
He must be died in harness.
Harness? Yes.
Must die in harness.
Harness?
Then this cause of action arises.
Harness, that no.
But
That,
there what happened? He
mother,
was discharged on account of his unfitness.
no, no reply. No reply.
Maybe it was a.
He said, I send your letter to the assistant manager.
Does not take up an employment cover. Render
ওই তো provide.
আপনারটা তুমি একটু আওয়াজ।
এটা ও সরি
এই জায়গার এইটা থেকে পড়তে এই মেম্বার সিজেস টু বি এমপ্লয়মেন্ট
তো কোনো চিঠি নেই তো। কোনো চিঠি নেই। পিছনে
where compassionate appointment prayer rejected when?
No reply. No. Just wait.
Did you move any
Yes.
petition
No.
claiming compassionate appointment? You are sure, Mr. Bhattacharya?
No. They have stated that is that question.
We are asking you.
No.
Petition delay হতে একটা
বাইরে also
ও স্কিমটাই আছে কিনা ছিল
এটা একটা দেখে না
স্কিমে যদি না দেখে তো কিছুই বলতে পারবে না।
And in the demand notice, it was stated that on 30th May 20.
You have no paper to show that you exercised option for pension or not. First. Second, you have to show us whether at all you are coming under this scheme. Try to understand this way matters cannot be disposed of.
But
We are hearing you since it is an issue.
only delay.
Not only delay is a substantial. We are in judicial review.
I know.
I am not the read court.
No,
if I find error in the order, we can interfere. There is no error in the order. 22 years you have slept. Court has said that on this ground I am not entertained.
Then when your logical that 14 years, after 14 years, that pension was granted. 14 years.
To whom? What pension was granted?
Pension is a claim filed after 14 years of retirement. That's he who retired. Claim.
What matter? Any other matter you are saying?
No, it's a reported judgment of Supreme Court. That is your losses, no such. Delay is not a ground. That is my submission before losses. Only on the ground of delay. But scheme says below 10 years he died, he is entitled.
Ashu heard Mr. Bhattacharya, learned advocate appearing for the
My xerox copy of the comment.
My lord,
Take back your scheme.
my lord, item number 27, Ronojit Chatterjee appearing for the appellant. Due to some personal difficulty, he is out of session, praying for not this week. Next matter.
Next matter টা ডেকে not to ডে করে দাও।
I'm for the respondent.
ও, এমনি
I'm for the respondent.
নেক্সট মান্থলি লিস্টে চলে আর যে দুটো করেছি না নট দিস কালকে আফটার সাপ্লিমেন্টারি লিস্ট